Honorable members, good morning, and also good morning to the Honorable Deputy Minister, the Chair of the Board of the Road Accident Fund, as well as your colleagues that are here. I think one or two I may be seeing for the first time, but I'm certain that you will do the introductions at the right time. I just want to register a complaint that humans are creatures of habit, and there is an order that has crystallized over time of how the members sit. And typically, even if I'm not looking, if I see like a hand, I will know that it's a Honorable so-and-so because they typically sit on that chair. I notice Honorable Burke and Honorable Atkinson are trying to confuse me in these proceedings by sitting at a different spot. I did ask Denzel to check the rules of Parliament to see if they are allowed to do that, and he told me I have no leg to stand on.
Chair, it's called expropriation without compensation.
I shall not make an issue. The only thing I will request, Honorable Burke, is that at least you wear the right color if you're sitting on that chair, because typically the person who sits there wears red. But I will forgive you on account of the tie that you are wearing. It comes close enough. But thank you very much, colleagues. I am sorry that we started a little late. It was entirely my fault. Otherwise, we like to start on time. I also want to say, Honorable Deputy Minister and your colleagues from the Road Accident Fund, I recognize that trekking from Pretoria or wherever you're situated to come here to be early in the morning, some of you, it may have meant taking the 5:45 flight. So we take none of that for granted. And also for those who are board members, that in the ordinary course, you've got other things that you do. And that you're not always ready at the drop of a hat to come and be in Parliament. So we really appreciate that you'd make the time and set aside your other commitments to be here. So please, I just want you to receive my appreciation on behalf of the committee that you have done so. So today's proceedings, I'm hoping that we should be done long before 5 o'clock. Long before 1 o'clock, because we're not dealing with the full spectrum of the audit outcomes as we did before. We're dealing with outstanding and arising matters, really. So I'm hoping that we'll have a concise conversation and then proceed from there. I just want to say that, and this is for the members, but also for your assurance, the Honorable Deputy Minister and the board chair and your colleagues, that we are quite cognizant that some of the matters we will speak to here relate to an ongoing investigation. We will take the necessary care that we do not discuss details which may, or ask for information that may compromise that investigation. This meeting is no different to the meeting we had yesterday. We had the National Lotteries Commission here yesterday. They also have an ongoing and sprawling investigation, which I think is wider in scope than that of the Road Accident Fund and may take years. Notwithstanding, we managed to have a constructive conversation and stay within certain parameters. So there may be instances, members, where I then, depending on what the question is, honorable members, I may guide the Deputy Minister and the Road Accident Fund to answer it in a particular way or not to answer at all if I believe that it may compromise the investigation, because it's important that we maintain the integrity thereof, one, and secondly, we also don't prejudice anyone, because an investigation is an investigation. It's not a pronouncement of guilt or innocence. That said, the reason we are here fundamentally is because the update that we received from the Special Investigating Unit touched on matters that we had canvassed as the committee before. And in that sense, it would be imprudent of us not to continue that discussion in light of the information provided to the committee by the Special Investigating Unit. But as I said just now, we still have to do that in a manner that is responsible and does not place anyone or institution at undue risk. So I will take the due care to do that. I will give you, Honorable Deputy Minister, an opportunity to make some opening remarks. as well as the board chair, and then you favored us with a presentation, which I really appreciate. Thank you very much for that. My view is that we need to go through the presentation. It's relatively short. I may, it's actually very short. We had a 60-slide presentation being sent to us the other day. So what I will do during the presentation, if necessary, I may ask some questions of clarification as I do. This is to enable the members to then ask the questions within context and that sort of thing. As I always do, please, in instances where there are acronyms, just be mindful, because the public watches, sometimes the acronyms are the same across departments and entities. So it always helps if somebody just explains what it means or says it in full. It also helps the record taking here so that we don't confuse institutions. But thank you very much. Honorable Deputy Minister, let me hand over to you.
Thank you very much, Chairperson, Honorable Chair, and honorable members of the Standing Committee on Public Accounts. It's always good to be here in one way or the other, Chair, and I want to say that as you can see in the presentation, the color scheme, my tie is certainly not a ref tie. It's a result of coincidence. But Chair, thank you very much for the opportunity to actually be here this morning, and we appreciate the opportunity to come and appear before Parliament to account. I would like to indicate that we have got the acting DG of the department, Matabata, behind me, and for the purposes of context, the DG of the department tendered his resignation at the end of February. And so Baba is actually currently acting, and we have advertised the post. So I know that members don't like acting people, but this is a recent development. Also, the chairperson of the board, Umam Franch, was next to me, and the deputy chair of the board, Dr. Mabuya, is here, and there are other board members and executives. Chair, I had ordinarily prepared one or two things to say to the committee this morning. However, I think I must start on the latest developments, which will place in context maybe anew how we are appearing this morning. And the board will explain further on some of the issues. Chairperson, last night I was advised by the board of the Road Accident Fund that at a meeting held on the 27th of May, the board had resolved in the exercise of its fiduciary responsibilities and duties in terms of the Road Accident Fund Act and the PFMA and King principles to place on special leave with full pay and benefits effective immediately the CEO of the Road Accident Fund. The board further advises that this is a precautionary measure and does not constitute disciplinary action. This decision is made in accordance with the board's responsibility to manage and control the fund as provided for in Section 10 of the Road Accident Fund Act and the accounting authority for the fund in terms of Section 49 of the PFMA. Further, this decision is taken solely in the interest of good governance and is a precautionary step to facilitate ongoing investigative processes. It does not imply any prejudgment or adverse finding against the CEO. The special leave arrangement will remain in place until the conclusion of the relevant investigations by the Special Investigations Unit or such earlier date as the board may determine. The board will review the situation on a monthly basis and communicate any updates. In this regard, during this period, Mr. Pat Lukareni, who is here, if he can just raise his hand, will serve as the acting CEO to ensure the continuity of operations. So, Chair, I thought I should start there because I believe that that places in context anew our engagement. And then to secondly indicate that as the shareholder, the ministry, this is a decision we support that the board has taken and believe that it is in the collective interests of the investigation, particularly in its final stages. As you are aware, you are in possession of a preliminary report of the SIU on RAF matters. The second point I would like to raise, Chairperson, is that at this stage, or up to now, we as the ministry and the department have not been briefed or appraised by the SIU on any of the matters of the investigations. We have not had opportunity to engage the SIU either on the matters, and therefore we do not have the benefit of the committee's perspective on matters which may be before it. Are we aware that there's an investigation going on? Yes, we are. But in terms of where that investigation is, in terms of whether there are any outcomes, all we have, Chairperson, is what you have, what we have in the public domain, rather, that there have been certain processes or issues and so on. However, that said, Chair, it remains our expectation as the ministry that the Road Accident Fund at board level and at executive level cooperates with the investigation until it reaches its logical conclusion, and for us then to receive the recommendations and outcomes of that investigation. However, I do believe that the board would have applied its mind in the matters before it, and in the matters before this committee, and in the matters before the SIU, to arrive at the decisions that they've arrived at. Furthermore, Chairperson, obviously there is a presentation to the committee, a report which seeks to answer some of the questions that had been placed before the board and RAF ahead of this meeting. I do want to, Chair, indicate that there may have been some toing and froing in terms of our presentations and communication and submission. It is my understanding, having discussed this with RAF, that it was in the context of trying to understand exactly the parameters of what it is that was required of the RAF in appearing before the committee this morning, but the board will further explain should the need arise. Chair, we obviously as a ministry remain concerned about the situation at RAF on a number of fronts, particularly to ensure that RAF is able to fulfill its obligations. These are issues around revenue generation, which I've ventilated here before. We've also indicated that there is a legislative review process which is underway, and we will be meeting with the board in June to, amongst others, deliberate on the bill which will be going to cabinet and coming to parliament, which seeks to review and reform the road accident fund so that it is able to move forward. There's issues, Chair, quite clearly, as you can see, which are before us around the leadership of RAF. In conclusion, Chair, I think it may be prudent in light of this decision to place on the record of the committee that the term of office of the CEO is due to end in August. It has been our counsel and advice to the board that the position ordinarily should be advertised for purposes of soliciting candidates, and in the event that the CEO, current CEO, would want to continue in the position, that he too should apply. I thought, Chair, I should place that now on the record in light of this decision, so that in the event that that is heard or it comes out, it is not seen in the context of this decision. We have communicated this directive or outlook prior to these developments, well in advance, for the purposes of due planning and governance and stability at the Road Accident Fund. Chair, with those remarks, I want to thank you once again for affording us an opportunity to appear before the committee, and through you, may I request the chairperson of the board to make remarks, and then, Chair, we will be in your very capable and friendly hands as the committee. Thank you, Chair.
Good morning, Honourable Chair of the committee, honourable committee members, our Deputy Minister of Transport, the Acting DDG of Transport, our board members representing the RAF, the RAF management, and the various attendees for this morning. All protocol observed. Good morning. Chair, I don't know, do you still want me to introduce?
Please, so I know most of you. So if you don't mind, you can just tell us the names. You don't need to ask each person to say who they are.
Okay.
If you are comfortable doing that.
Yeah, I'm fine.
Yeah, you don't need to introduce everyone else, just the people at the front here.
All right. Representing the board, thank you, Chair, for that direction. We've got Dr. Mabuya, I think she's been introduced, the Deputy Chair of the board. Dr. Dladla, the Chair of the Operations and IT Subcommittee of the board. And Mr. Nyama, who is the Chair of the Audit Committee. And Mr. Khotso Sirlo, the Chair of REMCO. So we've got the subcommittee and of Regal, sorry. Chair of REMCO, she's not here. Advocate is not here. And then representing the executives, we've got the acting CEO, Mr. Patu Lukwareni, and then we've got Ms. Manyasha, Mr. Modiba, Ms. Kumalo, the CFO, Ms. Bernice Potgieter, Mr. Pora, CAE, and our board secretary on my right, Mr. Pinani. So that's the full delegation. Chair and members, I think the DM has done the proper introductions and basically alluding to the matter. And I think, Chair, you've also elaborated on the fact that the matters that are before us are really not new matters. They are outstanding matters. And yeah, so we'll basically be updating you on matters that were deliberated in this forum before. Nonetheless, I think it's important that I highlight the fact that the initial, let me start by apologizing, Chair, because we were supposed to submit the presentation, I think, on Friday last week, but there were issues of legalities. I think there were letters that were written to try and protect individual rights with respect to the SIU investigation. And so, yeah, there were delays there to deal with the legal matters and also protect individual rights involved. And coming out of those letters, the SIU came back on Friday and stated that they acceded to the fact that they have not yet presented either the preliminary reports, or obviously there's no final preliminary report to the board, and they're saying because the investigation is still ongoing, but it is sitting at advanced stages, and they will only present to the board the final report when the investigation is complete, after they've provided all affected parties the right of reply. Remember, Chair, the one main point of contention was the fact that the RAF, up until now, we don't have that preliminary investigation, the detail of it, as well as the fact that it hasn't been presented to the board, and that the executive and any other affected party have not yet been given the right of reply. So the Friday meeting actually settled those matters. They say they will give us that right of reply when the investigation is being finalized, and then they will have a meeting with the board once the investigation is complete. So that's why then we did not include anything, because we didn't have any basis to put anything. We didn't have the reports. So that's why there's really nothing to that regard in our presentation. But we'd like to assure the committee that the board takes the role of this honorable portfolio committee seriously, and we understand our duty to account, to our parliamentary processes. And that's why we assure the committee that once the investigation is complete and we have been given, the time to discuss it, we will bring the matters back. So I think it was important for me to state that. And then, Chair, I think I'm going to allow Mr. Lukwarene to take us through the detail of the investigation. Thank you very much.
Thank you
With
very
your
much, Chair.
permission.
Before Mr. Lukwareni comes through, I also do need to provide some input and clarification, because it's important. When we have these hearings here about various public institutions, we expect a certain level of curiosity within those institutions to find out what was said about them, and to have regard for any documents that were submitted, because they are public documents, they are freely available. My assumption is that at the very least, the discussion between the SIU and the committee, as well as the documents submitted therein, is something that you have access to. In the event that you do not have access to, you cannot find them, the Secretariat is always here. Journalists ask for them and so on. And therefore, I am comfortable that we have the discussion on the basis of what is publicly available. It would, in any event, be imprudent to go beyond the scope of what has been placed on the parliamentary record in this discussion. And that is why I prefaced my, these proceedings by saying I am going to watch very carefully the parameters the committee stays within, and therefore we all need to stay within the parameters of the discussion we already had with the SIU. So we're not going to ask you questions like, who received money. We didn't ask the SIU, we won't ask you, right? We won't ask you which specific employee are you referring to in this particular case, or the SIU was referring to. We could have asked those questions. We did not ask the SIU those questions. For the same reasons that you advanced, we will not be asking you those questions. I have sent a detailed note to the committee members to that same effect, so that our inquiries here stay within the ambit of what is legally permissible, what protects the rights of people, at the same time fulfills the mandate of the committee to ask on matters of governance and financial management. And so I just want to assure you, Chair, that in the event that, whether your colleague might feel that please, those are the parameters. So whatever was shared here publicly, we're staying within those parameters. So just for us to be certain. I hope that is helpful. Thank you.
Chair, through you, Chairperson, if I may, I think it would be proper for me to, at the outset, reiterate rather, that one, we in the Ministry and Department have not been briefed by the SIU. Secondly, the Road Accident Fund has not been briefed by the SIU, and all we are going on is, one, being called by the committee and therefore appearing. Secondly, we are trying to answer the questions that will be placed before us. And therefore, Chair, I would want to request that that consideration be at the forefront of the committee's mind, also in the context of the powers and privileges, that what we say here, we do require the protection of Parliament in the context of an ongoing investigation. And that in the event where the board and the executives will have to return to provide or solicit information or check it during the meeting or make a written submission, beg the indulgence of the committee to do so. However, it is my expectation, Chair, that the board and the executives will, as far and as best as possible, respond to the questions of the committee. I think that disclaimer is important, because what we did not want, Chair, is ref not to appear. I think that would have been detrimental to parliamentary oversight. And to say to the SIU, we are readily available to be briefed, and we are readily available to receive the report and implement the recommendations and the outcomes of the report as and when it reaches us. Thank you, Chair.
No, thank you very much. No, I'm comfortable with that, Honourable Deputy. I noted your comments in the beginning. As you will see when the committee interacts with you and the Road Accident Fund, it will be entirely in a manner that either you or the board or the executives are eminently capable of answering. Thank you.
Thank you, Chair. I've already dedicated to Mr. Lucarene to take us through the presentation. Thank you very much.
Thank you, Chair, and good morning to the members. Good morning to the Deputy Minister and the acting DG. Do spare a thought for me. I just got the information about this responsibility this morning. So a responsibility I accept, and I will do to the best of my ability. But just take that into cognizance that
Don't worry, Mr. Lucarene.
Yes.
We will not let the bus drive over you since you've been thrown. You've been thrown under the bus.
Yeah, I'm already under it. I came here with the CEO last night.
But we will make sure it's not driven over you.
Who was going to present this report? But nonetheless,
So we will be patient.
Nonetheless, I will attempt to do my best. I must say at the outset indicate that. My understanding certainly is that we are not here to discuss the SIU report. We were given specific questions that were follow-up questions in relation to previous engagements, and we are in the similar situation in terms of the challenges we will have in addressing the specific issues around the SIA report, because we also have not necessarily been afforded the detail and the context around some of the issues. So we'll be guided by you around how we deal with that. And of course, I will just deal with the presentation as was submitted. So. In terms of the questions that were specific to the presentation, the first issue we needed to address was the provision of a list of law firms of attorneys currently being utilized by the RAF, the manner and the basis upon which briefs are split amongst these service providers, and the expenditure per service provider. Now, a list of the current panel was provided, and the current panel, as we've indicated there, was appointed and started around December 2023, and as a total of about 43 law firms. Now, only 19 law firms had been briefed and paid during the 2023 and 2024 financial year at the time of preparing the report, because I think this would have been what was presented to the committee at the time. And then at a total of 76 million was paid in 2023 and around 104 million in 2024 respectively. And I think there is an attachment of the specific forms. It's a panel which obviously the selection takes place as depending on the complexity of the matter. And once obviously a firm has started a specific matter, and it goes all the way through appeals to the various courts, ordinarily that same particular firm will continue with the brief, particularly the firm of attorneys. The current panel.
Sorry, Mr. Lukwaren, so I said I would occasionally interrupt
Yes.
for clarity. So I and the members have access to the annexure. So the committee sent a request to the Road Accident Fund in writing in this manner, and I'm asking the committee secretary to pull it. And I fully recognize that you've just stepped into the shoes today, so I am going to give you the allowance for that reason. Sent a request for the Road Accident Fund to send 2 lists to the committee with the information set out in a particular way. I asked for the top 10 law firms that provide corporate legal services to the Road Accident Fund, and then I asked for the top 10 law firms that represent claimants against the Road Accident Fund or plaintiffs. In our previous interaction with the Road Accident Fund, only 1 list was presented. I raised the issue of where the other list is. And I have just asked the desk to provide me with your chief executive's answer to that, because we were not provided with that list. I then requested in that meeting that that list be sent to us. That list was never sent to us. In the intervening period, the Special Investigating Unit came to brief the committee. And one of the things they told us is that one of the law firms has an incredibly disproportionate portion of the work allocated by the Road Accident Fund. It became clear, and this is where the two interact, where the issues we've asked before intersect with what we were told by the Road Accident Fund. We do not know what that law firm is, but you can see why that information is pertinent. It's still not been provided. Now, I recognize that you've just stepped into the shoes. What I need to understand is if there is anyone in the team here who interacts with our correspondence as a committee with the Road Accident Fund, number 1. Number 2, anyone who then makes note of what we say in the committee so that these things can be followed through. So I need to stop here because we need to resolve this issue now. It's gone on for too long. So I'm not placing you personally on the spot. I am now asking institutionally, because I recognize you just stepped into the role this morning. That information is necessary because it's a continuing line of inquiry by the committee that has now been amplified by what the Special Investigating Unit has provided to us. So can I understand why it is that it is easy to provide the plaintiff information, but it seems impossible to provide the corporate legal services information when the committee has asked for it in writing and in this sitting here?
Yeah. You want to go ahead?
I'll start, Mr. Lukwaren, and then you can deal with the detail. Chair, allow me to apologize to the committee if there's missing information that wasn't provided. And we will duly provide that. I'll make sure that that information is provided. And to answer your question in terms of who deals with the committee directly from the RAF, it's the board secretary. It's the board secretary that deals with this committee directly. And he also takes note of the, requirements and minutes in here when we have discussions. But all of us, we also do that, Chair. But we always assume that the CEO and the executive, because it's their responsibility to actually put the information together, and then obviously guided by him. But nonetheless, we've noted this. We will subsequently provide that information. But I'll allow Mr. Lukwaren to respond. Do you want to know? Yeah, no, if he's got any detail, he might know better because he's an executive. Thank you.
No, thanks, Chair. I think we do note that what was provided in the annexure is the whole list of the panel of attorneys, the firms, and what is required is the ranking, is the top in terms of payment. And I think that's if that's the issue, I think that's the issue that will then have to be given time to subsequently address.
Okay, thank you. So may I say something? So my difficulty, Chair, is that you were in the meeting. You know we've asked for this information. It has not been provided. I think I would not be unfair to hold you responsible for failure to provide that information, because the board is the accounting authority. And I have the letter here. What date was it? Okay, I will find the date. It was a follow-up letter to the Road Accident Fund. I wrote it myself. And it's been months of us asking for this information. And therefore, I have great difficulty in light of what the SIU is saying to us. I now believe that this information is being deliberately withheld from the committee for improper reasons. It has to be. And I need to know from you, Chair, have you asked whether this information was provided to the committee? Because you've been here throughout.
Chair, I do acknowledge the fact that you're holding me responsible for and accountable, and you're correct by doing that because I was here in the meeting. But like I said, we always expect that the CEO will coordinate the information, and most of the time it gets to us, and it gets submitted directly to you without us going through everything. I mean, we are a non-executive board, so we don't actually review everything that comes here directly, especially when it gets circulated at the last minute. That's the responsibility of the executive. But now I take full accountability to ensure that this happens. But really now that makes me become operational. But to respect the request of this committee, I will now get to that level to ensure that we provide that information.
I'll come to you, Honorable Black. Can I just get the assurance that this information was not removed from the annexure that we received? Can somebody give me the assurance that this information was not excised from the annexure that was sent to us? Because we've been very clear in asking for it. I did the bullet points myself. I drafted that letter myself. That's why my memory of it is as clear as day.
Through you, Chairperson, we do interact before we respond to the committee with respect with the Secretariat, Chairperson. If you were to analyze the response that was provided, lastly, it was a spreadsheet response, Chairperson. It actually contains the same information. That's why when we responded, a disclaimer that we placed before the Secretariat was just, this is just a continuation of the information that was previously provided. So in essence, Chairperson, just to directly respond to your question, for assurance, if you can just go back in retrospect to information that was previously provided, Annexure A actually contains the very information that is presented before the board, before the committee. But I wish to assure the committee, like the chairperson of the board has actually alluded to, that before Friday, we'll ensure that that particular information is available. But we do interact on constant basis with the Office of the Secretariat to ensure that the information that is being requested by the committee respectfully submitted on time in its relevant, Chairperson. Thank you very much.
All right, thank you very much. I'll come to you, Honorable Beck, and then Honorable Beasley just now, and you, Honorable Skosan. I did the questioning last time. The slide said corporate and other legal services. Is it that same slide that was provided here in the previous presentation? It said corporate and other legal services. The chief executive was sitting somewhere around that side. And I asked him, what does other mean? Do you recall? And he said, it's party costs and related. I then asked a follow-up question, which was, where is that other list I asked for? And it was not provided in that meeting. I have asked her to pull out the record of that exchange. That was in March, wasn't it? That was in March. where we had that conversation. It's May now. This was an exchange between us because it was a follow-up to the written request to provide it. That list had 10 law firms. I can still remember most of them from memory. One of the things I was concerned about, and this is where I'm going with this, there are names that appear on both lists. And the reason I'd wanted them set apart is to see them in context. And we still don't have it. Can I then ask that that information be provided to the committee as soon as possible? In fact, if it's possible, can you, since you say that you've got a spreadsheet, can you please ask someone to try and make it available, like forthwith, please, if you can do that on the email. Honorable Beck.
Chair, I'm sure get to our questions at the end of the presentation. I just want to take issue with the board chair's response. Can you help me understand, the latest data I've got is from 2014. What is your annual compensation as the chair of the board? Just a quick answer. This is in the public realm, you should know.
I think it's about 1.2.
So you get paid 1.2 million rand, which is the equivalent of a parliamentary salary. And it is in your mind too operational for you to respond to the board chair's request for information. That is beyond the scope of your work. Does that seem reasonable to you?
Chair, I did acknowledge your point, and I accept responsibility. I did, and I said that I will provide the information. So, honourable member,
Why haven't you? Why haven't you?
I don't have operational and executive powers.
You get paid 1.2 million rand. Why on that salary are you not willing to get involved in this operational matter? And how convenient is it that the CEO has been dismissed as of last night on a temporary basis so that he does not have to answer the question? Why have you not, on your compensation, bothered to mail the chair the requested list?
Chair, we will provide the information. I've already answered the question. Thank you.
I'm sorry you haven't. Why have you not?
Sorry, Honorable Beck. So I will assume, Chair, that you then just didn't think it was important enough because I've raised it twice. Honestly, I've raised it twice. It's been raised here in the committee, and you simply never bothered to check. We're not asking you to be operational. I am asking you to ensure that the needs of the committee are met by way of information. That's it. And it's simply asking, has this information from a discussion in which you were involved been provided to the committee? And you get a yes or no answer. Honorable Beasley.
Thank you, Chair. So I just found the response by the chairperson absolutely dumbfounding. I mean, I saw the list that you've asked for. It's not an extensive list. You read that top line there, what it actually says. And to me, the board is acting with impunity. And Deputy Minister, my request to you is write letters of termination immediately because the board is acting with impunity at the moment. They're treating Parliament with disrespect, and it's totally, totally unacceptable. If you read that top line there, it's actually asked, the fact that the chairperson can't actually go through the slides, the requested information before this meeting actually shows a level of impunity and disrespect for Parliament and for the people of South Africa and for the beneficiaries of the RAF. It is totally, totally unacceptable.
All right. Honorable Skosana, thank you, Honorable Beasley. Honorable Skosana, your hand was up.
Yeah, no, thank you very much, Chair. Yeah, I think the response by the chair of the board is totally unacceptable, Chair. Chair, besides the letter that you are referring to, which was a follow-up that you sent to RAF, even the latest letter that you written on the 23rd of May, last week Friday, in response to Mr. Mujalifa Mutolani, who was acting on behalf of the CEO, and also in response to the chair of the board, Mrs. Zanele Lorraine Francis. I think paragraph 9, you listed things that we are going to deal with in this particular meeting. And in that list, 9.1, it says, just to quote it verbatim, the provision of a list of law firms stroke attorneys currently being utilized by the RAF, the manner and basis upon which briefs are split among these service providers and the expenditure per service provider. The latest letter that the chair written on the 23rd, this matter is here. And I don't think the chair can say she is not operational. She's they are a non-executive board. I mean, if you are obviously invited by an institution like Parliament as the chair of the board, before going to that meeting, there should be a preparatory meeting where the board and the executive, they sit and says, what are the issues that we are going to present in that particular meeting? You can't say, okay, I'm invited to the meeting, I'm going to the meeting, but I don't know the team that I'm going with, the CEO or whoever's going to do the presentation, are they going to present what is required by the committee, by Parliament especially. So there should be a preparatory meeting. I mean, that's what is done all over. If you are invited to a meeting, especially being invited by Parliament, there should be a preparatory meeting whereby you look at what is required, you look at the presentation, whether the presentation responds to what is required. If there are amendments or alterations that need to be made, they are made. You can't just take a flight, book flight, and prepare to go to the meeting not knowing whether in that meeting you do have a presentation that responds to the issues that are required in that particular meeting. That is totally unacceptable. You can't say I'm not operational or an executive board. But then what is your function? Because you play an oversight on the executive and the administration of the RAF. So you can't just come to the meeting without having met before and look at your presentation, whether the CEO or whoever who's leading the administration has responded to the matters that are required by the committee. This is totally unacceptable. Thanks.
Thanks very much, Honorable Skosana. So I think we've kind of dealt with this issue for now. I'm hoping that we will get this information, but at this stage, it feels like this information is being deliberately withheld from the committee. And we are going to come back to this query later on. Please proceed.
Chairperson, if I just want to get clarity, if I may, through you, Chair. I heard you say, can we get the information forthwith? Was that now, or was I heard the chair of the board indicating Friday? Because there are executives here, right? So
Let me
I wanted to
clarify.
just get clarity on when you want it. So
Somebody gets hold of whoever is head of legal services and ask them to provide that information today, before we break at 1.
can that be facilitated, please? The CFO is
Yeah.
here, Patu.
Yeah,
please.
it will be.
Thank you.
It will be.
The first request, by the way, was on the 6th of November last year. That's how long ago it was. That's why we can't wait anymore.
Okay. Thanks, Chair. So, yeah, consequently, then the presentation then expresses the briefing and the spend in a way that obviously is not specific according to the list of firms. I think that is just the summary of what has been spent. And then I think, as we indicate there, this is corporate litigation matters only, and that obviously is in respect of the 43 firms in the list. And I think we will provide. I think the list will then indicate the amount spent on each of the law firms, and I think that will then provide the better context for the engagement. Thanks, Chair, on this. I think that's all on this on the item on the law firms. The second part is on the irregular expenditure, and I think I will also request the CFO to assist on this one on the specifics as they are required. In terms of the presentation, I think we were expected to address the issue around the treatment of risks identified by the committee, including the RAF providing the detailed list of. I see the slide is on vetting on the other side. Yeah, I think this is where we are. The treatment of risks identified by the committee include the RAF providing detailed list of actions taken against officials responsible for incurring irregular expenditure. I think we attempted to list there the specific irregular expenditure items identified.
Chairperson, my apologies. I hate to do this to you.
All right, sorry.
My apologies, Acting CEO. We are trying to solicit information, and I would hate for us to be half present. May I beg the indulgence, Chair, for a 10-minute break, the executives to align themselves about who remains in the meeting and who will be outside getting this, unless there's any other information that would be in this presentation that you want, and you can point us to that. And then I'll ask the chair and the CEO to just split the delegation into two. We'll have a working group outside and a team present here so that there's maximum focus. I would hate to disrupt the meeting. Thank you.
All right, I'm inclined to agree. So I thought that you don't have one of your legal department people present.
She is here, but
here.
the CFO is also here. So
I see. Okay, so I will indulge with the 10-minute break, if that's okay. So the time...
Chair.
Sorry?
Thanks, Chair. Can we just stipulate exactly what format we're wanting it in? Because I've been an accountant and one can present information that can be quite creative. So I think if you can specify exactly how you want
Yes.
the information. Thanks, Chair.
Okay, so have regard for your previous presentation to the committee in March. That presentation listed the law firm and provided the amount that has been paid out to that law firm. There was Deprolio attorneys, there was a Geldenes Malachi Incorporated, etc., etc. Provided exactly in that way with the financial year concerned. So I think now in this instance, at least the 2 financial years will suffice. That is basically to date. In fact, the 2 financial years that ended in March and the financial year that ended in March last year, that should be sufficient. You don't have to go back further for now. If we want that, we can get it in writing later. Thank you. So I'll provide the 10-minute break. It's 9:58. We'll be back here at, I'll give 12 minutes. So we'll be back here at 10 past.
Person, thank you very much for your indulgence.
Honorable members. Honorable members, please be honorable. We are starting now. Thank you.
Chair, thank you very much for your indulgence and allowing us the opportunity to engage outside. We've got the information that is required, and the executives for legal will present it, and at a determination in the meeting that the chair will so make, and then we can conclude on the presentation and field your questions. Chair, and I want to prefer an apology for us having to request for that opportunity to engage, and I appreciate that the committee has granted such. Thank you.
Thank you very much. Let me do this because I am supposing that your presentation is kind of set. It might take time to further edit it, that go through it, and then at the end, just present the information, and then we'll go to questions. So move on to the next issue, and then we'll return to this at the end.
Acting CEO, you were on the platform and you were trying to get the CEO to present on something on the irregular expenditure?
Yes, Chair. I wanted the CFO to take us through the regular expenditure slide. Bernice? Oh, I think she's still in the law. But I can in the meantime continue with it. I think it's as you can see, is in relation to, this is what has been confirmed for the 23-24 financial year. There were 3 instances of irregular expenditure that have been confirmed. The first one is it relates to non-compliance with the National Treasury Instruction Note 3, that is in relation to the appointment of a supplier that did not submit an SBD form. That's a procurement issue. The employee responsible was warned with a formal written warning. The second one relates to the compliance verification in terms of tax compliance, where the award was made prior to the verification being done from a tax compliance perspective. And this is also a procurement issue that the responsible official was also received a written warning. And the last instance relates to the travel management framework, where the employee traveled without proper authorization, and in this particular instance, the full amount incurred was recovered from the responsible official. Those are the only 3 instances of irregular expenditure that were reported and confirmed for the 23-24 financial year. Thanks, Chair.
Yeah, no, proceed to the next issue.
Okay. Now, in terms of the final one on vetting of senior officials, I think this has also been an ongoing one. I think the addition that we agreed that I think maybe we need to do on this one, because all the forms have been submitted to state security. I think the additional information we'll need to do is to provide the specific dates, because obviously from here on it's beyond our control from a rough perspective, because then it's a state security responsibility. But I think for purposes of the committee understanding the length of time, we'll be able to then subsequently provide those specific dates that they were submitted. But as we indicate there, all the Z2O forms have been submitted to SSA for those listed above.
Thank you very much. May I ask a question for clarification? There is something that does not match here. On the 16th of October, we were in this room, and I asked a question. The chair and I had a bit of an exchange about the vetting of officials. But one official was said to already have been vetted, and that was Mr. Collins Litzwal. Is his name there erroneously?
No, Paul, you want to clarify that?
Thank you, Chair. Good morning, members, Honorable Deputy Minister. The name of the CEO is not there erroneously because the CEO has previously submitted his vetting forms, and currently I have an email that we were trying to confirm before this meeting how far the vetting process is with the SSA. And so previously he was vetted, but Chair, if you would know, SSA does vetting for certain individuals on a periodic basis. So I think he was now doing the second, his second vetting. If I may, Chair, just indicate from the email I got the day before yesterday. Just give me a second. Sorry, just a second. I've got it received from, I think, the SSA themselves. Chair, while I look for it, maybe let me just move on to the dates as we were requested to also
don't-
indicate.
Please don't move on to the dates
Okay.
yet.
Okay, let me look for the email.
Yeah, so a follow-up question is, would it be your contention that his previous security clearance, or clearance, let me say clearance, not security, let me say his previous clearance would have expired between the 16th of October and March? Because when we concluded last time, I actually said I didn't have time to ask my own questions. And this was one of, you had a slide like this last time. And his name was on that slide. And I wanted to ask this question in March already, because I had a very specific exchange with him in this meeting where he said he has been vetted. Because if he said so then, and this is the state of affairs now, it means for the second time he lied to the committee. And I'm saying for the second time because I asked him about the treasurer in the organization in the same meeting. He lied about that. So I need to know, I really need to know. And the question is, did his clearance expire in between October and March? That's the question.
Chair, I think for purposes of this submission, I think we were only reflecting the submission for vetting as it relates to the RAF, because I think the vetting prior might be the time when he was still in the Department of Transport. I'm saying for purposes of vetting of senior officials, I think that's the context. I personally, for example, would have been vetted before I had a top secret security clearance in the past, but by the time I joined the RAF, it had since expired. So I had to now submit a new form. But to the extent that you are referring to a confirmation that you would have made in the previous meeting, I think it's only fair that that gets confirmed. And I think it's not an issue that can be easy for us to respond, except for confirming the one that relates to the submission to the RAF. I think the rest we can be able to go back and verify if by the time that he had joined the RAF, there was any expiry of any previous vetting certificate.
Honorable Atkinson had his hand up first, so I'll give him a chance and then I'll come to you, Honorable Beck.
Chair, it's been 7 years. He was acting CEO for 2 years and he's been in that position for 5 years. Has he actually ever been positively vetted in that time? And now, the reason for the problem with that is the fact that he's actually not been legally appointed to that position, which then raises a question as how then would he have locus standi to take RAF, to take the actions against the Auditor General in court that he's been doing? Has he been doing that based on the fact that he's actually not a properly appointed person? So in fact, a misrepresentation to the courts. Because without the vetting, and I understand the courts might give him 6 months or a year to get his security clearance, but not 7 years. So if he's been operating for 7 years without a security clearance, it raises a massive legal issue. It also raises an issue about a whole variety of things here, about the accounting principles, about the fact of not paying out medical aids and foreigners, about a whole variety of board minutes, which he bought, which are actually illegal. Because, to my understanding, if he hasn't been vetted and had a positive vetting in 7 years, he hasn't ever been legally appointed, and he actually raises the entire question over his whole legal mission against the Auditor General, because he doesn't have the locus standi on behalf of RAF. Thank you.
All right, so I don't know the legal part, so I must be honest with you. So I'd need to be advised. Honourable Beck, but I take your point. Honourable Beck.
Chair, can we have a show of hands from the board and the execs present here, who in fact is in possession, as it stands today, of a vetted status? Can you just put your hands up, please? Am I to understand that not a single member here has been vetted on the board or the executive level? Is that correct? The chairperson can answer for all of them. Is that correct?
Can we clarify that, Chair? The least we can do, the best we do when it comes to vetting, Honourable.
Sorry, this wasn't my question. My question was, are you in possession of a vetted status at the moment? Not, have you submitted it? Are you waiting for the SSA? I've got a simple question. Is anybody here vetted?
Yeah, the ones that have submitted that are on that list there, they have not yet received.
So nobody here is vetted, is that correct?
Yeah, we don't,
I'm giving you the benefit of the doubt. You still have that for a moment. If you perpetuate this cycle of not answering this committee's questions, you'll be subjected to the same limelight as your predecessor. So be very careful in what you say next. Does anybody here have a vetted status?
I think I've answered.
No, you've not.
Yeah.
Yes or no?
No.
Thank you.
A positive vetting status, no. And can I clarify the other issue, Chair, around the appointments? That because the vetting process is generally, it takes a long time from the state security. All the appointments are subject to receiving a positive vetting outcome. I think that's normally what is put into the contract, because I think it's a process that is beyond our control, and all of us sign contracts subject to that. And I think that should not necessarily be. I just wanted to address the issue that the appointment would have been illegal. Thanks, Chair.
All right, thanks. So I'll come to you, Honourable Deputy Minister. So here's my difficulty. I am looking at my notes here. The answer we received, I believe October last year, I might be mistaken. Ms. Matut, was it October or March? October last year. Was that the vetting is being finalized. In fact, the people have even been interviewed. That's what we were told then. So is it your assertion that, so it was being finalized, I don't know how many months ago it was, right? That at this point, nearly, it's going to be a year in October again. Interviews done, so you've not had to actively do anything between October last year and now, because it was already being finalized in October. Because, and please be certain of your answer, because I am going to send a letter to the responsible minister and ask for the correct information, and secondly, ask that minister to account for why it takes so long. We were told it's being finalized.
Yeah, I can't be certain of a date. I think on the certainty of the date, I think that will need to confirm. But certainly, that what I can confirm is that the Z2O forms have been submitted. Some on that list have been interviewed, including myself. And I know the CFO as well. So I think it will be different from one person to another. But certainly, like I've indicated, I think what we need to be able to do to affirm this is to give you the specific dates of submission to SSA, so that there's alignment.
Let me ask you, since you are interviewed, when were you interviewed?
Interviewed, I think, was late last year. I don't remember the specific. I think late last year.
Let me assist you. It would have been before the 16th of October then, because you guys were here on the 16th of October.
If I may assist with the dates there, the State Security Agency conducted interviews on various dates for the following executives. On the 8th of May 2024, they interviewed Mr. Collins Litswalo, they interviewed Chief Financial Officer on the 24th of April, Chief Strategy and Transformation Officer Patuli Kwareni, Daniel Pora on the 20th of May, and also Ms. Mampi Kumalo. As at the 20, so we do follow up with the SSA on a regular basis. As at the 23rd of May, which is last week Friday, we requested a report from the SSA in respect to follow up on the vetting status of RAF executives. And the report we got was that all the executives' work, vetting status, is field work. Field work meaning that they are still conducting interviews, they are still assessing the information that is in front of them. As Patu has confirmed, I think all of us have been interviewed. Some of us have gone for polygraphy tests. Some of us may not have been interviewed because of other reasons, but most of us have been interviewed. Our references that we put on the forms have also been interviewed. So the status that we got from the SSA on Friday is that it's at field work on it. In terms of the CEO, Honorable Chairperson, the previous status that was presented, I think Patu's name was also there, indicating that they were vetted at that point. And then Patu's vetting expired, that's why he needed to provide a new one. The CEO's vetting, as it stands with the SSA, we are following up with them because the email we have received from them, it's that there is no new record. He was previously vetted. However, now there is no new record. So they have not indicated the status of the CEO's vetting at the current moment as at Friday, as I'm indicating for all other executives. Thank you, Chair.
Thank you very much for that information. However, it still doesn't satisfy and let me say this. I will not hold either the Ministry of Transport or the RAF responsible for the tardiness of the SSA. We will take that up with them through the responsible minister, so do not be anxious about that. What we need to work out is whether the committee was misled. When the chief executive said to this committee that he had been vetted, I have the video. I have now learned with the Road Accident Fund to go and rewatch the entire proceedings ahead of coming here, because things that were said in the previous meeting change in the next meeting. That's why I can play you the video. It's here. He said he had been vetted. Is it your answer then, ma'am, that you don't actually know when his status would have expired? However, that being the case, if he was interviewed in May last year, it means when he claimed to the committee on the 16th of October that he had been vetted, he was lying. It has to mean that. It can't be both. Honorable DM.
Thank you very much, Chair. May I request that that question be put to the substantive CEO? However, at the same time, it would be incumbent on REF to provide the committee with the full schedule and timelines of each executive's vetting process, insofar where it is. Thirdly, Chair, to indicate that this issue of vetting is at the uppermost of our minds as the ministry generally across the ecosystem of the transport portfolio at executive level in particular, because there is a 2014 cabinet decision that executives and SCM practitioners must be vetted for the purposes of the work that they do. I would not want to delve into the legalities of the outlook that Honourable Atkinson has spoken to. We can look at that, but my understanding is that there's a cabinet decision. And then lastly, Chair, I would want to support your proposal that you engage with the SSA on this matter, and I'm pretty certain that the committee secretariat will draw you to the timeline that Parliament has engaged in on this matter as far back as 2017 on the key question of vetting, with the then Minister Bongo, Minister Dlodlo, Minister Godwa, and Minister Nchabeni on the issue of vetting as a priority issue for parliamentary oversight. And we will benefit as a department from that process, because it will help us be able to clarify it. But I would want to say, Chair, the executives can provide the timeline of vetting, because the issue, Chairperson, that this is not our process. It is an SSA process. Thank you.
Thank you very much. Honourable DM, that notwithstanding, let me place this on record. The submission of the colleague from the Road Accident Fund is that the chief executive was interviewed in May, on or about May 2024. On the 16th of October, the chief executive of the Road Accident Fund appeared. Okay, did I say something wrong?
Chair, I just want to clarify here the information I have in respect of the interviews is that I cannot say that the interview for the CEO, the CEO is being interviewed for his executives. So the interview I'm talking about here, it was not for interviewing of his own vetting. Yes.
Okay, thank you. Okay, which makes it worse. So anyway, what we know is that the chief executive turned up here on the 16th of October and informed this committee in conversation with me that he had been vetted, the other people needed to be vetted, and that their vetting was being finalized. In March, the submission of the Road Accident Fund is that the process was sitting with the State Security Agency for finalization. The status now is still the same. There is a contradiction between what the chief executive is saying and what was subsequently presented to the committee. Then we will need to resolve that issue, because I warned last year, and I was speaking to the chair about the importance of being truthful with the committee, and that we would take an extremely dim view next time this happened. This is why it's important. The second reason it's important is that the SIU has told us there is somebody with 2 ID numbers at the Road Accident Fund. This is why this basic process is important. We're not on a silly fishing expedition here. It's now through bitter experience that it has become important. Honourable Beasley, and then I'll come to you, Honourable Matla.
Thanks, Chair. So I'd like to ask the chairperson if she is aware of the CEO's vetting status, and maybe she might say it's not her responsibility. You know, I actually don't know, as directors, Chair, what is your responsibility if you don't know whether the CEO is actually vetted or not? And And you spoke about getting received 1.3 million a year. My suggestion is you pay back the money because it doesn't seem that you're doing anything at all. Thank you.
Thank you, Member. My knowledge was that the CEO was previously vetted and in his previous job, and then when he was appointed here, he has submitted his vetting information for the current position, and that the process was still work in progress.
The Honourable Madlala.
Thank you, Chair. I want to just propose that we finish the presentation. I think it's a 7-slide. We could have finished this in 5 minutes. I know that there are heated points of discussion so that we have a flow of debate on all the issues. But I think if we can just finish, we'll accept whatever we are told, and then we'll interrogate it after as at a holistic level. Thank you.
The Youth League's proposal is accepted. Thank you. Okay, I'll accept the proposal. Initially, I'd wanted to get that clarity because, yeah, anyway.
Yeah, I think this is now the final slide. There was an issue around the fact that the committee had received accounts from various sources alleging intimidation or harassment of RAF officials who are perceived to be sharing information regarding financial malfeasance and with law enforcement or other government institutions. It would be remiss of the committee not to raise these various serious allegations with the RAF and receive a response to the same. And then I think in our response there, we were saying that we are not aware of these allegations. Specifically, I think, and the RAF is obviously open to staff members to anonymously report any act of intimidation or in the workplace through whistleblowing mechanisms. I think we have that in place, and I think to the extent that we do not have the specific issues that would have been raised with the committee. The assurance that we can only provide the committee is around the whistleblowing mechanism that we have, and obviously there are matters that from time to time do get referred to the public protector, and then I think that is the process that we have, and I think it's a very difficult one for us to respond. I think with that's the best answer we could provide. Thanks.
All right, thank you very much for the presentation. So what I'll do is I will go this way. No, I'll start with you because we're going, and then we'll come this way. So I will take you, Honourable Neil May, and
Sorry.
Sorry.
You flight the last slide, please, on the information you wanted. Yes.
Thank you for that reminder. Please, yeah, show us that. Will you need some time to set it up? I'll indulge you with a few minutes. No worries. Thanks for the reminder, Honourable Minister. Is that the list? Looks pretty. Do you need assistance?
Yeah, it's projecting your chair.
Oh, yeah, okay. Yeah, okay.
Yeah, I think. Yeah, I think. Thanks, Chair. I think this was the.
This was provided.
Yeah, this was the previous one.
Yes.
For the plaintiffs. So I think we're just struggling with the one for the panel. I can see it here on the iPad, but I think there seemed to be a technical challenge in taking it to the other side. But it's here. It can be provided to members if we can have a mechanism. But I think that one certainly is for the plaintiffs.
No, this one the committee has. We've seen this.
Yeah.
The one that the whole point was about getting the other list.
Guys, the slide was present. Just email the slide to him. He can flight it. Bagit, yabona lento eseyenzeka sengizoqala ukucasuka. I'm sorry, Chair.
What is the difficulty?
Send it via WhatsApp, send it via email.
No, Chair, it says it was submitted, but it says outdated. The draft was deleted from another location. So I think it got lost en route. I don't know. I mean, I'm not a technical person. That is what it's saying. So we just need somebody to assist, technical.
Okay, shall we proceed with the questions in the meantime? Can somebody just go and sort out the technical issue with your IT colleagues?
There's the slide.
All right, thank you.
Yes, Chair, that's the that's the list finally. I do hope that. But I think the principle is to demonstrate that it's ranked.
No, we want to see detail.
Yeah, no, it's there. It's. I think it's in. I'm just saying that it's cut on the first paragraph there.
Okay, I am struggling to see.
Yeah.
Sorry.
Yeah, Chair, the proposal is that I will send to System Tombi so that if it's possible, she makes copies for individual members of the committee. I don't know if that
Okay.
makes sense.
Sure, can you read the totals? Okay.
While they're trying to, could I ask a question of clarification, Chair?
Yes.
I can, with my younger eyes, still decipher some of the numbers. It seems the top law firm in 1 year alone extracted 55 million rand plus from the RAF. How big is that law firm? How many attorneys?
So, Honorable Beck, so let's just go through the information and then go along the and go along the. So, we need to have the information in a manner in which the members can see, so that they can ask the relevant questions, please. Okay, so what I will do is let me make an allowance. So let's do it this way. Let me make an allowance for you to solve the layout problem quietly while we have discussions about other matters for now. And then when we put up that slide, we will then discuss the issue of the legal costs. Is that fine? Because there are many matters. Then we don't put you under pressure as well. Okay, Honorable Beasley, Honorable Neil May, and Honorable Pila.
Thank you, Chair. So I've attended quite a few meetings at Scopa, but I must say this is the most shambolic one I've actually attended. And Minister, Deputy Minister, everything rises and falls on leadership. You know, we've seen leadership turn some sunken ships around SABC, Eskom, and the lotteries yesterday. My recommendation to you is you need to act. If you think this is acceptable, what's happened today, then I don't know. You know, I hold you in high regard. You need to do something, Deputy Minister. This can't carry on. You know, it makes a laughing stock of Parliament. Directors are earning fees, and this is shambolic. It's absolute. You've been chair of you must have seen some things in your time. I don't know if you've seen it as bad as this. This is shambolic. And action needs to be taken. There needs to be accountability. And my sense is the board needs to be be terminated. Deputy Minister, don't you think it's extremely fishy or bizarre that the CEO, the day before, night before Scopa, was his services were suspended on full pay? I mean, happy days, full pay. He doesn't have to come to Scopa. He's not accountable to Scopa. Happy days, full pay. Surely, Deputy Minister, you should have insisted that he be here today. I mean, how can he get that notice the day before? And I think the board must take us in, not their confidence, because it is public information, when they actually had this board meeting, and can we have minutes? And it's absolutely bizarre that the day before he's meant to appear to Scopa, he gets let off on full pay. It's totally unacceptable. And Deputy Minister, you should have insisted that he be here today, because you have been chair of Scopa, and it's taking Scopa for absolute farce. It's taking the people of South Africa for a farce, and it's totally unacceptable. And then just, you know, the way that this board is acting with impunity in terms of their dealings with the SIU and the AG is just totally unacceptable. So I just want to highlight that, you know, there are some efficient organizations in government. The SIU's one, the AG's one. We hold them in high regard, and they should be treated by the RAF in high regard. And then just in terms of the last one, your financial years come to an end in March. If I could just have an understanding what the losses or surpluses for the year that's just passed. Thank you.
No, we'll go to 3 members. Honourable Neil May.
Yes, good morning, Chair. Good morning, Deputy Minister, and good morning to the team that is here with you and to my colleagues. I'm going to start off with, very similar to the question that my colleague is saying, is what specific oversights, and this is to you, Minister, what specific oversight mechanisms has the ministry implemented to ensure that there's no further maladministration within the RAF, and how are these being monitored for effectiveness? The other questions that I want to add, and this is also pertaining to the cancellation of the panel of attorneys without a backup plan. So this is to the acting CFO. One of the areas that is of concern is that and it looks as though decisions are made willy-nilly. And so there was a cancellation of the panel of attorneys without a backup plan, which led to increased default judgments and unnecessary legal costs amounting to 4.78 billion. How does the RAF plan to address the systematic issues identified in the reports, such as poor planning, lack of representation in court, and flawed decision-making? Chair, I want to move on to, so let me add, I've clustered the questions. And coming back to the payments to attorneys, how does the RAF ensure that blocked payments to attorneys do not unjustly prejudice claimants? And what steps are being taken to resolve the accumulation of interest on these blocked amounts? Chair, finally, what progress has been made in looking at the periodic bank reconciliations, checks on writs of execution, and review of the claims payment process? We are curious to know how the RF plans to address the systematic weaknesses, and including document management, user profile deletion, and the impact of ransomware attacks on critical information. Chair, the last thing was with regards to the board. I think, as you heard here, and one of the areas is, why has it taken the board so long? Having seen the reports from the AG, surely that would have given you red flags. I mean, that is one of the areas that one, with a logical mind, with your oversight, you would know that there's a challenge in your organization. And finally, how are whistleblowers and internal stakeholders being protected and supported in reporting misconduct or inefficiencies within the RAF? Thank you.
Thank you, Chairperson. Good morning, colleagues. Good morning, Deputy Minister and the team from REF. My first question was on vetting of senior officials, Chairperson. So since this item chose to become the man of the match today, I won't dwell much on it now. But I just want to check from the executive and the board, is it not possible that senior officials are properly vetted before appointment, so to prevent potential risk which is associated with unvetted leadership? The second question is on financial accountability. How does REF justify the payment delays and non-cooperation with the SIU investigation, including the outstanding 4.4 million owed to SIU? The last one, what steps are being taken to ensure timely payment of invoices and full cooperation with the investigation, so to avoid further delays and legal consequences? Thank you, Chair.
Thank you, Honorable Bila. Honorable Deputy Minister.
No, thank you, Chairperson. Let me be very quick to indicate that on numerous occasions now, every time I've appeared before this committee, I have indicated that where REF does the right thing, it has our support, and where we disagree with them, we will put it to them. The board knows full well that we have indicated that they should not continue with the court action against the AG, because that has resulted in unfavorable court outcomes on the part of REF at the cost of the taxpayer. To my surprise, REF is continuing to go to the Concord, right? So what I'm trying to indicate, Chairperson, is that we've got a problem at REF, right? On the 9th of June, I've scheduled a meeting with the board, which is my belief that we'll be able to ventilate all these issues and put the ministry and the department in a position to be informed and to take decisions about the state of affairs at REF. Honorable Beasley, am I happy about what's going on at REF? No, I'm not. And rest assured that we will respond in kind to how REF chooses to engage with us when we have been very clear about our expectations about what needs to happen. But why are we here today? We are here today because there's matters which we need to respond to insofar as the issues have been raised about REF. I'm sure you have seen my frustration at this meeting today. It's not my job to micromanage REF when there's a board and executives. But I see today's meeting certainly not as symbolic, Honorable Beasley. I've seen it as an enabler to take decisions about REF. So I see opportunity in crisis. And secondly, no, I do not think that there's anything sinister about the decision of the board to place the CEO on special leave, understanding that a meeting took place, and the board can explain why that meeting was called yesterday. Because everything, Honorable Beasley, has a context. This is not a willy-nilly occurrence. My understanding is that the committee has been briefed by the SIU. We are expected to come and appear before the committee on matters, some of which we are not privy to because we've not been briefed. When we are briefed, we will be in a position to act. What I don't want is to act on the basis of a briefing that was not given to us. I would want to caution the board from doing the same. But what is my expectation is that when the report lands on their desk, they must act. Right? I think, Chair, it may be, there's two chairs. Chair of the board, it may be helpful now to clarify how the board arrived at the decision around the CEO, so that we don't leave any ambiguity in the committee. Secondly, my understanding of the decision is it is to enable the SIU investigation to run its final lap to a logical conclusion. Where I have issue, and I will still communicate this with the chairperson of the board, is that I think there must be clarity on the terms of the special leave, and insofar as the interaction of the CEO and REF and the staff at REF. So I think we will need to clarify the letter further in terms of what it means, so that there's no ambiguity on the REF. But it's a decision that we support as part of due process of bringing the SIU investigation to a logical conclusion. Secondly, I don't think, Honourable Beasley, we're in a position to give you those numbers now, because the audit process is still underway for the year that has just ended. It ended on the 31st of March. The AG process is underway, and we will table the annual report when those audited outcomes come out. But where I think, Chair, it's going to be helpful. Oh, and I think, Honourable May, here's the issue. The red flags you speak about, I don't think REF can say they don't know. Because in the previous administration and previous parliament and now, they have been told that do not continue on this course of action. Right? So I would really want the minister and myself have been very clear on the status of the situation around the AG, to the point and extent to which we have said, if you are in disagreement with the accounting standard, it is for the Accounting Standards Board to make a determination on the applicable standard. It is not to say we are imposing a standard, but what the AG is saying is that what you are currently using is not acceptable, nor recognized. So I've dumbed this down to say, find one that does. Now, I do not believe that it is for the court to determine an accounting standard. I don't. We will be setting the wrong precedent, in fact. And I want to reiterate here again today, the board does not have the sanction nor the support of the ministry in this fishing expedition. I believe it is reckless, I believe it is irresponsible, and the board will be well served to reconsider its position on this matter. I don't think I can get clearer than that on this matter. Because what this has done, Chair, we continue to remain on a trajectory of dealing with the accounting standards and not the global situation at REF. What has been done? At the initiative of the ministry, we have been working with the DOJ and the executives of REF to resolve the court challenges insofar as the court role is concerned. That is work underway. 2 weeks ago is it when we met with the Deputy Minister of Justice and his team and our team to continue resolving this. We'll be engaging the courts themselves. But Chair, let me conclude by saying this. We must not be ignorant to the fundamental risk which prevails at REF because of the lawyers. The abuse of the system and the leakages of money not reaching claimants, in part, is as a result of the construct of REF. These slides here, in whatever form, why are we spending so much on legal fees? It tells you, it should tell you. We should be spending money on claimants, but we're spending money because the whole system is fundamentally structured in a way which is problematic. Hence, the amendment, the bill rather that we will be bringing, the REPS bill, it will come to Parliament. Should we continue paying illegal foreign persons in South Africa? No. We have stated here before the extent to which, because of the actual studies that have to take place about each claim, having to convert to dollars and euros, bleeding the ecosystem because we're paying foreign nationals. There's a question that has been asked that came through to Parliament. We can provide that to the committee about how much we have paid to foreign illegal immigrants in the country. Should we be in a position to continue from a financial management point of view, charging R2.18 at the pump per litre to fund REF? Because National Treasury is trying to review the budget. You all know the challenges we have around budget. So REF has to explore other sources of revenue. All of that, Chair. So when the question is asked what we're doing, we are equally alive to the challenges at REF. But where it's key, the board must assist us focus on the matters that matter. And this court action is a distraction. Thank you.
Thank you. There were other questions, so I'll assume either the chair or chief executive will. Sorry? Yes, that's what I mean. Yeah, they should answer the other members' questions.
We'll start with...
No, sorry. I thought, I apologize for the disconnect. Thank you, Deputy Minister. I think let me note your very emphatic point around the position of the department regarding the court action against the Auditor General, and also your statement that the board should reconsider its decision so it can focus on paying the claimants. I note that, Deputy Minister. Regarding the decision taken by the board yesterday morning to place the CEO under special leave, and I have to be cautious here because I have to protect the individual's rights, because everybody's got constitutional rights as well as rights in the labor laws. So I'm not going to go through the detail, but I will take the offer. We still have to sit with the DM and brief him in terms of all the details that led the board to get to that point. But the fundamental issue that the board reasoned was that there was a serious potential because of the personal conflict in terms of the issues relating to the current investigation, and the CEO's role as the head of the RAF, of the operational head of the RAF. Because before we came in here, there was a dispute between himself and the board in terms of attendance here. After Chair, the SIU matters have been cleared. But we must also remember that the CEO has taken a decision to actually instruct lawyers to represent him on the very matters around the SIU matters. And I mean, to us, we saw that as a conflict, because when we were asking questions, are you attending? And he said, no, he will have to check with his lawyers. So we had a problem that we have a CEO who's appointed in the organization, but is taking instructions from two different principals. And then the priorities of the organization is basically compromised. So the board decided to say that this is just a summary of the main reason, but there are other factors coming to. So we said, let's give him time off for him to go and deal with his personal conflicts around this process, and also his role, and also take time to reflect in terms of what is important, so that the organization is not brought into disrepute regarding this matter. And also, the organization and the board mustn't be seen not to be supporting the parliamentary structures that we're facing here. There are other specifics, Chair, that I'm not going to bring in yet, but I'm going to bring to some also impacting on the quality of the presentation that have been brought here. But I'm not going to go into that. But Chair, so that's basically one of the major reasons that you can't have a CEO taking instructions from elsewhere regarding the matters of the organization, and also taking personal litigations on the matters affecting his role as the CEO. So that's basically the main reason we've placed him. It's special leave. I mean, he hasn't been found guilty of anything. I think that's very important, that we just say he must just go and deal with the serious potential conflicts and its impact to the organization. And then that's why we're saying the board will review the matter on a monthly basis and go back and give him updates in this regard. And also, we've communicated with the SIU, and they've confirmed, they've given us dates between June. So the board will meet with the SIU and then maybe get some sense of because the other serious allegations that we've received from the Ministry of Transport was that there's allegations around serious potential interference by the executives of the RAF and some staff members around the SIU investigation. So the board takes those things seriously. So we thought that let's distance him from the process and allow the investigation process to be finalized.
Thank you, Chair. I need to have this in simpler English. I am trying to understand where the chief executive's personal interest would arise in this matter at all. We had the National Lotteries Commission yesterday, and they dealt with us, and they deal with the SIU as a state entity. So I just want to understand, are you suggesting that, are you saying to us that the letter that I received, which I have shared with the members, all of them have it, the letter, was written to us by the chief executive's lawyers in his personal capacity? Because I know that I just need to know what words mean here, so that when we get asked later, we can represent you accurately. Where would the personal interest arise? I'm just trying to understand what the CEO's difficulty in your understanding would have been. What did he tell you?
I'm trying not to get to matters that will affect his rights. And I mean, I can't be specific on that matter, Chair. Can I just send a written response to that? And then the committee can decide how it deals with it. May I request, Chair?
I may grant that. However,
Please.
please just remember your microphone. I may grant that. However, it needs to be on the basis of proper understanding. For example, I am assuming that the Deputy Minister was reading from the letter to yourself from the board. I made that assumption. When you were explaining the suspension, or even you, Chair, because you were reading the Deputy Minister. And here's my point. If you have matters of concern which relate to the conducting of the investigation without interference, a letter that relates to those matters would then have conditions of the special leave. Those conditions would be: hand in your laptop, you may or not. You may not interfere with the investigation, don't contact any employees, don't come into the premises, etc., etc. It doesn't say you're guilty, still out on full benefits. But we now have this situation where the chief executive is on special leave. We're not certain why. It might relate to the investigation. But actually, if he wanted to, he could come up back and hang out in the canteen during the day and give people cold stares. So please help me there.
Chairperson, no, thank you very much. Let me indicate that obviously this is a development which is substantively very new. The board is yet to brief us substantively on the set of circumstances, some of which have been alluded to now. And what I would request, Chairperson, is that we be afforded an opportunity to look at the special leave. Because I think the other thing I must correct, it's not a suspension. I've been made to understand that it is a special
It is special leave, yeah.
Special leave.
Thanks.
The board would probably, as I've said, have to expand on the terms and conditions of the special leave. We will need to satisfy ourselves on the basis of the report they will give us, and therefore the terms and conditions. My understanding is that this is to enable the SIU investigation to arrive at a conclusion. That ecosystem will have to be explained. We will have to satisfy ourselves, Chair, that due process for this special leave has been followed. What I would request, Chairperson, is that we be afforded an opportunity to engage with the board, and we will provide a report to the committee on these matters. I think the board will have to also then explain to the committee on the issue of the lawyers and his personal lawyers. Chair, please underline one thing in what the chair of the board has said. When she says the quality of submissions today. You see, just underline that. For whatever it may mean to the committee. I'm not going to say read between the lines, and I'm not going to speak on behalf of the chair. But for me, it's a matter I'm going to interrogate with the board, right? What does that mean? But what it substantively points me to is that, Chair, the exchange of correspondence over the past week or past few days has fundamentally, I believe, led us to this moment. And I would want to believe if that is the case, then it's the correct decision to have been taken by the board. Because the SIU investigation must be concluded. I want a final report from the SIU. And I'm happy to hear that a date has been looked at in June for the SIU to brief REF. We want that, Chairperson. So may I beg the indulgence of the committee that one note that a special leave has been granted, and we will come back to the committee on that. I think let us rather err on the side of caution, Chairperson, on this one. And I say this because now lawyers have been invoked. That's what I'm hearing, that lawyers have been invoked. And so I don't know what will follow next, Chairperson. Thank you.
All right, thank you. Deputy Minister, I have difficulty with the request. I have difficulty with it because the committee and the public are really none the wiser. So let me then play back to you, Chair, what you said, maybe in simpler language. Okay? That firstly, you could not reach agreement as to the substance of the presentation before the committee. So that was dispute number one. Dispute number two related to the manner in which the Road Accident Fund would continue to interact and cooperate with the Special Investigating Unit in its investigation. Would those two statements be correct? So I'm trying to say it in a way that doesn't compromise anyone's rights, but at the end of the day, there has to be simple English that explains your decision. Do you understand? Otherwise, if you or I get asked of the Deputy Minister, we will speak Latin, which is something nobody can understand. So I need to, so is it that there was a dispute between the board and the chief executive with regards to the content and substance of the presentation to this committee, which relates to accountability to Parliament? The second one relating to the manner in which, in your view, the Road Accident Fund institutionally should continue to cooperate and assist the Special Investigating Unit. Would that be fair without compromising anybody's rights?
Chair, yes, but that's not all. There are other fundamental issues behind it. That's why I don't want to get into detail because it's now kind of a legal matter. So there's more behind that, but I agree to the points you're making.
Okay, so let me then, so at least we've got these two things on the table and on the public record. Otherwise, the committee is agreeing to something it doesn't understand, and I think we will be held accountable for acceding to a request we don't understand. May I then also grant you your request to appraise the committee in writing? Can I do that? Would that be fair? But that appraisal needs to happen expeditiously. You don't need to sit and do it outside, but let's do it at a mutually agreeable time so that we can move on. Okay. Thank you. Sorry, we were continuing because...
I ask that we brief you within the week. We will find opportunity to engage the board on a special basis outside the meeting of June 9, and we will submit a report to the committee. Thank you.
All right, thank you. Then, yeah, okay, I'm happy with that. Thank you. Can we assist Honorable Neil May and Honorable Bila with their questions?
Okay, thanks, Chair. I think let me deal with the specific questions. I think there was a question around the amounts owing to the SIU. I think from where we sit, I think we are up to date with the payments with the SIU. I think the last invoice was of 750 that we paid, that we got from the SIU. I think from time to time we engage on those issues. I think if there are any issues, I think there's a process around how we resolve those, including, of course, any information that they require. They have, at least to our knowledge, all the information and documents that they require to conduct their investigation, and we continue to support the SIU in the process. I think the issue of possible vetting before appointment, I think it was ventilated before around the extent to which we're able to control the process. I will not repeat that. There was also an issue around our measures around protection of whistleblowers, which are highlighted, that we even have internally ourselves our own whistleblowing policy. We even have an independent service provider who is responsible for handling whistleblowing reports on behalf of the fund. I think we have a full forensic investigation division that handles issues of investigations, detection across the board, and most of the investigations we're able to do from the from internally. And there were also issues around reconciliations and writ management. I think that's important. It is strengthening that reconciliation processes that has resulted in the identification of the duplicate payments. That was subsequently referred to the SIU. I think for recoveries, I think it's important to always emphasize the point that it is through those introducing those processes that we're able to identify them internally through improving those measures. And I think you'll see that even in the previous reports from the Auditor General, there is that acknowledgement from the report of the Auditor General around the improvement of measures, particularly introducing reconciliations to ensure that payments are not made unduly. And I think that then brings us to also the issue of blocked payments, which has also been a contentious issue, because it's also an issue that it's a measure that was put in place to also prevent payments that are fraudulent, that may have issues that may need to be further investigated, and obviously that has created challenges in that it may result in payment delays. And I think there have been instances where we have had those challenges, and I think we endeavor to try to ensure that at all times payments are paid, and even where possible, there have been attempts to get certain payments to be made directly to claimants, but this is not always possible. But I think it's an issue, it's a challenge that we continue to manage, because we need to balance between ensuring that we make the right payments to the right claimant, but also ensuring that we don't pay payments that make payments that are fraudulent or irregular. So I think that is a process that we continue to manage, and that goes also around issues of document management. I think these are processes we continue to improve. I think our digitization project I think is well on track. I think it will obviously go a long way in ensuring that we improve our processes and systems going forward. Obviously, the RAF still remains largely paper-based, because obviously that's how the legislation has designed it, and I think we've canvassed that point also previously, and the Deputy Minister has made the point around ensuring that we move with regard to the present amendment of the RAF Act to ensure that we were able to improve the systems in the RAF, and I think those are the issues I'm able to respond to. I think there's a specific issue that relates to the SIU investigation chair. I think that I would prefer not to engage on, but I think the rest, I think, were issues that I can be able to talk. I think the DM did speak to the issue of the surplus and the losses that is not yet audited, and I think we'll deal with that when the issue of the AG report is finalized. Thanks, Chair.
Thank you very much for that. Just please remind me on the SIU issue that you can deal with. What was the question?
I think there is an issue that refers to the cancellation of the panel tender. That is a specific issue in the SIU.
Okay, so let's park that question.
Yeah.
We will come back to it because we have had regard of information from outside the SIU, a judgment delivered last week. We will talk about that later, so that's fine. Because it's on my list of questions. I have shared what that judgment says with the members, so they've got it, and if any of the members want to go over that ground, you don't need to leave it to me, you can ask it. But it traverses the same ground, because substantively we have to deal with the issue. So as I explained, what we've done is where there are matters that traverse the same ground as the SIU investigation, we will then deal with them in the manner that we're also dealing with the other issues. Thank you. Members, I am mindful of the fact that we're in a weird situation where we had to take a break, and I don't want to keep members too long. Can I then ask that we take a body break for about 10 minutes so that we can then continue until the end once we come back? Would that be fine? It's 11:32. Let's come back before 1:45. Thank you. Honorable members and colleagues, shall we resume? Believe it or not, I want to release everyone on time. And in that spirit, may I ask that we, and I will mind myself as well, so can we just be as concise as possible? I don't want to say to follow Honorable Bila's example, but she gets to the point in ways that I also can't. So let's try and emulate her in this process so that we can also release the colleagues who must travel. Thank you very much. May I ask, Honorable Skosana is sitting next to you, so I am now, what I'll do is, if he walks in, I will still give him a chance as the third member. So, Honorable Matuna, please go ahead.
No, thanks, Chair. Good day. Chair, I see that you emphasize that we must be precise when you are coming to me and Honorable Madlala.
Oh, no, this is a coincidence. I am just mindful of the time.
It can't be a coincidence. No. Thanks, Chair. I will as well try and be as short as possible. I think I will start with just one. I think the first question I would have will be around the issue of the duplicate payments. I just want to check that's far as rough the steps that we have taken to prevent these from happening again. And also, I think it would have resulted to a loss of approximately 340 million. And how does RAF reconcile? How do you reconcile your payment systems now to ensure that claims are not paid twice? And the measures to recover these funds, how far are you with the recoveries in working? I think you said you are working with around them with SIU. Secondly, Chair, around the fraudulent payments, I remember at some point we spoke about this, where there were fraudulent payments that were submitted by employees, including the redirection of funds into personal accounts. Now, I just want to check with progress, how do you ensure that you have robust internal controls now to prevent such fraud from happening again? How far are you with your plans to recover the 1.9 million that you had identified on these fraudulent payments, and do you have any disciplinary hearings taken place against the implicated employees? And what I want to check, Chair, I think what confuses me, as I'm being very short, I want to check the issue because I was under the impression that the CEO is on a precautionary suspension, but I'm told he's on a special leave. And I think according to the directives that would have been issued last year in May in 2024, around the granting of a special leave and so on, I think the board, as much as you would agree to it, that it must give some of the reasons. I think I'm of the view that I might be incorrect. I think Honorable Madlala, because I know he was a professional in that field, he might assist us. I'm of the, I don't know TM, but I believe that you need to apply for a special leave for you to be granted one. It's unlike the process. It's unlike when you are on a precautionary suspension for a particular matter and so on. So can we be given clarity? He's the CEO on a precautionary suspension, or is he on a special leave? I think that is important that we get clarity there, Chair. And Chair, I think as well, can it just be, I do not think there would be any personal matters, whichever it may be in the two, that we cannot be indulged on in terms of the reasons that would have made the board to arrive at that decision. And I wanted to specifically ask, was he interfering with the investigation of the SIU? If yes, how? Thank you, Chair.
Thank you, Honorable Maduna. Honorable Skosan.
No, thank you very much, Honorable Chair, and good afternoon. All protocols observed. Yeah, Chair, with regards to the issue of legal panel and expenditure thereof, the RAF appointed a corporate legal panel of 43 law firms in December 2023, but only briefed and paid 19 firms. And expenditure on legal services amounted to 76 million rands in 2023 and 104 million rands in 2024. So my questions are as follows. What criteria do you use to allocate briefs, or what criteria have you used to allocate briefs amongst the 43 law firms? And why have only 19 firms been briefed and paid, despite the panel being established for corporate litigation matters? My second question, how does RAF justify the significant increase in legal expenditure from 76 million rands in 2023 to 104 million rands in 2024? And what measures are in place to ensure cost effectiveness and equitable distribution of work among the firms? My third question is, given the limited use of the legal panel, what steps are being taken to optimize the panel's utilization and ensure that all appointed firms contribute to reducing legal costs and improving litigation outcomes? My fourth question is with regards to whistleblowers, especially within the organization. How effective is your whistleblowing mechanism in protecting employees? Do your staff members feel safe to report misconduct without fear of retaliation? And lastly, Chair, it's a comment on the issue of the special leave. I think we appreciate and support your request that we be given a written report regarding the special leave with clear definition of what kind of leave is it and the legal provision associated with it. Because as we sit here, I think this whole situation is quite sketchy. So I think if you can keep given something in writing like you have requested, because somebody can interpret it differently. Somebody can interpret it like a gentleman's agreement that the board said with the CEO and said, because you are only left with 3 months and there are a lot of things that are going on and your name is being there. So for us to save you, you better go and stay at home for the remaining 3 months so that you don't have to account to anyone. And then at the end of 3 months, by the end of August, you are able to exit peacefully without anything. Somebody can interpret it like that. So I think it will help us if we can just get something in written with all this information. Thank you very much, Chair.
Thank you very much, Honorable Skosana. Honorable Madlala.
Thank you, Chair. I'm not sure if I have got questions. But I definitely have comments. Definitely.
You are allowed.
All right, I think we'll start with the... I know that it was ventilated in bits and pieces, but I want to just echo my own sentiments on some of the utterances by the board chair, which were very unfortunate. One of them was that information comes through to Parliament without the board having had sight of it. And I think that's That is unfortunate. That shouldn't be the case. Whether it could be attributed to the relationship between the board and management or the inefficiencies of the board, that's another discussion. But it is an unprecedented situation because you come as a delegation. As a matter of fact, even the deputy minister cannot be exempted from that allegation. If he was to say that I was not aware, we would have a problem, because you'll obviously be expected to be having a briefing caucus on these issues to check the ticks, to tick the boxes and make sure that all that the committee has required is provided, including the information around the vetting. I don't think there's more than 15 executive members at RAF. So by head, as the board chair, you should just know that these are vetted, these are not vetted. I don't think it's scientific information. I think it's just basic information that I would simply remember because I've been with these people for the past 3 years or so. I can't really need a report as and when it happens. I should know it by head. So I think there are issues that we may need to consider in relation to the efficiencies of the board or whatever could be the circumstances leading to what I see as a structural and governance ineffectiveness in the institution. And I think, Chair, we'd have to make recommendations around that. And then the issue of I know that you've made your own agreement there, Chair. We did not want to interrupt it about the issue of the precautionary or the special leave of the CEO. But I think it's important that we register our own views as members of the committee on the subject. Well, as a human capital expert in my own right, I find special leave when attached to issues of certain allegations as an English way of justifying precautionary suspension, because the two are not the same. And if you are saying that there are investigations, there are issues, and then you say it's special leave as opposed to precautionary suspension, I think you're just playing with English. You just don't want to come out firmly. Because precautionary suspension would say, obviously, it's a suspension pending investigations to allow that there must not be interference with evidence and all of that, and to clear the space for an investigation to be concluded. But in this particular case, we have a situation where we're informed that there's already a preliminary report, which means a lot of investigation has taken place. And we're at a point where there was a right to reply requested. And during the process and the beginning of the investigation, there was no precautionary suspension or special leave. Now, what arose in my mind is what new evidence has been brought to the table or that came suddenly, which then necessitated that let's have the special leave. And let's have it just a day before the CEO comes to account to Parliament on the follow-up matters and other related matters. And obviously, it raises quite a lot of questions on my side. Special leave will be a different kind of an arrangement. Because if you are going to be consistent and say for everyone who's dealing with their personal issues and attorneys in an organization, you are going to be granting special leave. There's annual leave, there's different forms of leave that a person can do to deal with their personal issues. But if it's related to investigations that are happening, it ordinarily would not happen at a stage where there are even preliminary reports, because these investigations have been going on with the CEO sitting in the position. And we have not heard that there was interference, unless if that was the case. So I think it's really a bit malicious to then say it on a day before, and the acting CEO says he arrived yesterday with the CEO in Cape Town with an understanding that the CEO will be presenting. So the meeting took place yesterday morning. The CEO still arrived yesterday night, and the acting CEO was told this morning. So if you look at the sequence of events, I've got quite a lot of questions with it. Unless if the CEO came here without knowledge of the outcomes of the morning meeting, or if he came here in his personal money, with his personal, not money of the company, because otherwise there will be a cost that someone must be able to account for. But also, what would have been the dire or the damage to the entire process if we had had him here? Could be suspended after. I have no issue with whether he's suspended or whatever, but I'm saying, what is the urgency? What could have really been so bad about him coming to present himself or to present before this committee today, in between the hours of his suspension and now. So I do want us to be cautious, Chair, not to play into the gallery of internal politics at RAF. And I don't stand here to defend the CEO. And we must litigate matters and ventilate them with much objectivity as possible. But also we can't just sit here and accept that there's going to be someone who will be sitting at home for 2 months getting full package and full payment, and we cannot find logical reason for that. You know, and the report that is due to come may come in the next 3 weeks or 2 weeks or whatever the case is, and we have taxpayers' money being paid for somebody who's not doing the job, who's not accounting, who's not having his side, or not his side of the story, because we're not a forum that deals with that, but who is placed in a manner that I would deem as malicious on special leave, and also special leave in under normal conditions, beside how the concept has been just generally used. When you're on special leave, you are not generally prohibited. You are still an employee. It's unlike precautionary suspension, even though you are an employee there. But with special leave, nothing stops an entity from saying, come back to account on ABCD if you are on special leave. Like you were saying that either we say that your laptops are seized, all information is seized, you are on precautionary suspension, you are suspended, you don't want you in the premises. But if you are on special leave, nothing prohibits you from accountability from the entity saying that we want certain information, because there are questions in this room that cannot be answered by the acting COO or by anybody in this room except the substantive CEO, who's not here to answer those questions, and it deprives the committee from its full functionality. So I think
Mandla, can I make a suggestion?
Yeah.
Because I think what may be helpful in your comment is for you to nonetheless attempt at asking questions relating to process. Because you've made the comments, but the comments, I think, need a response. So you've said, for instance, that the meeting took place in the morning, he was still coming here, etc. So there are certain questions I believe you may ask, such as, was it your view that the CEO's presence here would not be desirable, and if so, why? So in other words, we don't leave it in the realm of comment. It's still hanging if we do that. So can I ask you to reformulate some of your thoughts into questions? We can deal with whether they're able to answer them or not, but formulate them as questions so that we actually get a response as the committee.
Thank you, Chair. Let me just restructure them as following. Question number one. Yeah, no. I'll restructure them in my head quickly. So the first question I would like to understand is, why did the CEO come to Cape Town? As a specific question. Yesterday night, what new information could have necessitated that the special leave has to happen before this day of Parliament, the timing of it? What information came through between, let's say, some time before the meeting yesterday, which then necessitated that the special leave must be with immediate effect, considering the fact that there's this meeting today? That's the second question. The third question is, was precautionary suspension not a considered view of the board as opposed to special leave? And is it the view of the board that his continued presence as the CEO would impede on any evidence, on any investigation, would impede on any ongoing investigation? Maybe let me ask those few questions. Thank you, Chair.
Thank you very much. May we give you an opportunity to respond, starting with Honorable Maduna's questions.
Chairperson, I think that substantively, maybe to give an understanding so that the board can place all the issues before it as questions. The briefing that we have at Ministry is that the board met in consideration of events of the past few days, which I dare say were triggered by the invitation by Scopa. In attempting to come here for this meeting to account and answer to the issues that members are raising and to the submissions that were required, we ran into a problem about this meeting. I wrote to the board last week after it had indicated that it had difficulty about this meeting and the process and SIU. I said, go and ventilate those concerns there at SCOP about the SIU process. So what I can tell you is that coming here has not been easy. Right? For the board, because it had to contend with the situation as follows. See, a CEO are made to understand who now invokes his lawyers on his rights about a matter substantively for public accountability. My understanding is that the board was placed between the rock and the hard place, because it wants to now, after we have engaged and they met and they took a decision, that it is to come and appear before the committee. That's why I said earlier on, underline certain things that the board chairperson is indicating to you. So the request, Chair, to say, let us now come back to the committee, and Sozabe is to say to you, the submission by the board on this matter will be next week, by no later than next week, to the committee. So it's not a prolonged. And I've asked that this matter be placed on the agenda of the meeting that I'm calling with the board. Because at there are issues here. I mean, the question you put about why the CEO came to Cape Town, and when the acting CEO found out he was acting, I placed to them outside when we had our engagement. So, Chair, what I would hate is a situation where we give you uninformed answers. I can, Chair, at your earliest convenience, once this matter is clarified, come back to you. In fact, we even have to brief the portfolio committee on this development as well. Right? And then to say the assertion that, or the assumption that it may be interpreted to say sit at home until your contract has, no. That's why I was very clear at the beginning that this development is quite apart from the filling of the vacancy. Secondly, this is not a ref matter per se. This is a matter of a subject of an investigation. I think so. I think it wouldn't arise, right? Secondly, or thirdly, Chair, is to say, when the chairperson says, amongst others, the chair of the board, the quality of the information that you have received as one of the reasons for this decision, I think colleagues must be able to look at that with the merit it deserves. We had a problem. And the chair says, we've given special leave, go and reflect, CEO. I think that's the word she used, go and reflect. Now, this is a decision that is somewhat 36 hours, give or take. The board will provide a report to us. We will report to Parliament on it. And I think some of the questions that and comments members have made assist us interrogate it better and understand it better and establish it better. And I think that, Chair, we want to indicate that it is favorable that we afford an opportunity to this process to be rounded up by the board itself. But I would want the chair of the board to just answer on some of these issues for the purposes of clarity for the board. But what I can tell you, Chair Ngoba, you do know the towing and froing that we have had. There's been a problem. There was a problem about the appearance here. I told my office that I will go to Scopa regardless, right? The board took a decision after having interrogated the issues and been clarified on issues that it would attend. As at yesterday, to be fair, I was advised that the CEO was not coming to this meeting. It's news to me in this meeting that the CEO flew into Cape Town last night. It's news to me. You see? So what I'm saying, the whole ecosystem, Chairperson, there's a problem. And that's why I make the point, Honorable Beasley, that for me this is not shambolic, because it helps me zoom in closer to where the fault lines are in order for the corrective action to be instituted expeditiously. So that's why I said to the officials outside, this whole thing, who started acting when and so on, will also have to be clarified, because there's multiple interpretations. So, colleagues, let's just present the facts and our knowledge as we know it. I'm telling you what I know. I was told that the CEO is not coming. I'm surprised that he flew into Cape Town last night, but it will be explained, right? Also, lastly, the CEO is not lost to REF. He's still an employee at REF, and will have to, at a particular point, and I'm certain the board will afford him the alterum partem on all the issues that have been ventilated here. So I just think the only thing, Chair, is that, yes, this happens on the eve of this meeting, but pointedly it happens because of this meeting. Maybe let me just be as that frank, so that we dismiss all other allegations of suspicion. We are here because there was issue about this meeting, and I was not going to have a situation where this meeting was not going to be honored. It won't happen under my watch. If we are called here, we'll come here. Thank you.
Thanks very much, Honorable Deputy Minister. So I need to say, for the benefit of everyone, so I'm the one who received the letters, okay? I also had no idea that the CEO was coming at all, because he was very clear, and I've shared it with the members, that he doesn't believe that he needs to be here. In the course of my preparation for these meetings, I also have extensive discussions with related agencies, i.e. the SIU, so that I may understand if there is anything that I am missing. The reason I am allowing asking for information to be provided publicly to provide certainty, and some of it to be provided in writing, is that if I shared all of the information that has been provided as part of the back and forth that was being done by the lawyers, we might also actually do an even worse job of prejudicing people's rights, because there are some serious allegations involved. It's my view, Honorable Madlala and Honorable members, that as much as we want all the transparency here, it is prudent that at the very least the chair takes further legal advice from Parliament. I really would say that. And I've taken extensively significant legal advice, and I've also asked the legal team to be here. So it is a bit of a kind of difficult situation, because we got 2 letters. I've shared them with the 3 letters. Letter number 1 was from the chief executive. Letter number 2 was from the chair of the board. They substantively said the same thing, that they're not going to come here, or they don't want to come here. Part of the process that I have to do in the background is to make sure that, notwithstanding, people appear before. And that is when my interactions with the ministry began, because I have to say it's your job to make sure that the meeting is honored, right? So that's the first thing. Got a further letter to say there is, and I've shared it with the members, to say we must not even mention certain names in there, or even positions. things I consider to be offensive to the work of this committee. And I've shared that with the members. So I'm now sitting here in the chair. I don't want to call a break so that I can consult again. So can I suggest that we continue? I think it's the safest thing to do, because I am just concerned that in the process of getting to specific answers, we might actually do something that legally later we might be told you shouldn't have gone that far. That's my concern. I'm privy to some of the information because of the preparatory work, and I'm doing the best I can under this circumstance to balance the chief executive's rights and the right of this committee to transparency. If I were to not achieve that balance, we'll be here until 5 o'clock, and there'll be 15 journalists here, and I don't want that. Okay, let's do things properly. Take advice, in my view. This is not ideal. I'll take advice, further advice from Parliament, and then we can decide whether we call the RAF again, we ask the CEO to come, etc., still an employee. I would rather we do that so that legally we do the right thing. So let me put it that way. So that was the reason, Honourable, but your questions are helpful in that the Deputy Minister has now provided further clarity. The question that is important that Honourable Madlala has asked, and I think it needs, what he's telling us is that there is a material difference between a precautionary suspension and special leave. And we need to get to a point where that question is meaningfully answered, because it also relates to what I had asked earlier, which is, are there conditions to this? Because when reasons are shared for the step being taken, you get a sense that, okay, this is taken as a precaution, this step as a precaution, but then the precautionary steps are not there, which is I think that was your point, Honourable Madlala. So anyway, can we answer the questions, including Honourable Madlala's questions, because I think that question is important. What I would be interested in, did the board take legal advice before taking this step? As an example, right? And you were advised accordingly, and in substance, this was the legal advice, etc., etc. It will help Honourable Madlala and the public to understand how you arrived at the decision.
Chair, the board did not take legal advice. We were advised by the advocates within the board, because we do have an advocate within the board in terms of after the decision was taken, in terms of how the decision must be communicated. But the intention, the intention of the board was to just place him on a special leave to go and take time to deal with the matters at hand. It's not a suspension. So it wasn't intended to be. And then I think the next process was going to unfold, where we're going to sit with him and agree on the conditions, which is going to happen, urgently, because remember the decision was taken yesterday. So the next step will actually transpire in the before the end of this week, basically. Because it wasn't a suspension, like I said. I think the Deputy Minister have just made it quite clear. This meeting was classified as unlawful. Even executives were not supposed to attend this meeting. So the board, yes. So the board had to deal with that issue without, bringing all the other matters urgently. So it was an urgent decision that needed, and the minister was saying, I can't have a board that's not willing to account. And then we said, we're not going to come here without the executive. The board had to instruct the executives after the decision was taken in our open meeting. We said, the board has taken a decision that the board is attending SCOPA because it has a duty to attend and account. And then the board is also instructing executives to attend. It's on record in our minutes, in our meeting. So that was an urgent situation. So the conditions, Chair, are going to be dealt with. The other matters, I did say there are.
No, I just want to assist you by way of explanation, therefore. Again, I will put it to you. Is it then your submission to the committee that the chief executive was not allowing his subordinates to come here?
Yes.
Okay,
An answer. No.
Okay, so that at the end of the day was the issue, and the board had to make a choice about whether it comes here alone or it comes with the executives for the full accounting year. That was the issue. Yes. Okay, that's better English. Okay, Honorable Madlal.
1 second. One, I have a problem with the deputy minister answering more on the decision of the board, which is not his decision, which he still needs to sit down with the board and have a brief on and an understanding of. Number two, if someone does not want to come to a committee and you are a higher structure, you give them an instruction and you charge them for insubordination. You know, you don't say they must go and reflect. You see, that's my other problem with some of these things. We seem to have a very laissez-faire kind of an attitude, a very relaxed kind of a tone. Because we must deal with an issue of a person who does not want to provide accountability, if that is the case. And say, we're putting you on precautionary suspension on the grounds of insubordination because you refused a lawful instruction. And you can take it to your lawyers, you can deal with it in court, whether that instruction was lawful or your attorneys are saying that it should have not been the case. But we must have a decisive kind of character of leadership so that we can ensure that there's stability and then deal with the legalities. Well, this is a labor relations matter more than it is, while there may be other issues of litigation and court processes. So that's, then we said, go take time to reflect. You see, I thank you.
From an HR perspective, I get you. So colleagues, at least we've got to the reason. Now, I referred earlier to the fact that there is a back and forth. So we did receive a presentation here in the first instance, which the Road Accident Fund asked to withdraw. There is innumerably more detail in this presentation than there was in that one. That one was an insult to this committee. It was an insult to our collective intelligence. And so I've asked the secretary to find that presentation and share it with you. We were being insulted by an official who does not believe that this committee should even take a presentation from the SIU at all. At all. That's the situation that we're facing. And so I agree with you, Honorable Madlala. This situation needs to be clarified. It cannot fall on any official's mouth to instruct people not to come to account to Parliament. This institution will be gone. We cannot have that. And that was the situation. The back and forth. This presentation is going to be shared with the members. It had one-liners, which I regarded as an official version of Futse. Honestly, that's the situation. So the reason I want us to move and to move on, there are some issues to traverse here, but in its fullness, we had a situation where this committee, that's why I consulted the Parliament legal team, because we had to decide whether we then issue summons for people to be here. And I had said initially, we use summons as a last resort, and it really was getting to last resort. And in the end, I actually didn't know this morning whether the chief executive was coming or not. I had no idea. I just knew there's a presentation. I wasn't sure who's coming. That's where it was. So that is why I'm allowing a little bit of the sort of, because it's just, this is a live situation in many ways.
I think that I must correct something, because it will leave a diluted and cloudy perception. We are here to account. One thing, I'm not going to be an ornament here. It was the Honorable Madlala who said we should have had a caucus, using his words. Now I mustn't speak. I don't think it's a fair characterization of the situation. Secondly, I've indicated here I was saddled with the situation of a ref that in its entirety was not coming to this meeting. So I think we need to make up our minds about whether we come here or not, and whether we come here to speak. But at the heart of it is that we are saddled with a governance challenge. at the Road Accident Fund. We are saddled with a situation wherein we had to ask the board to come and ventilate. I said to them, the issues you have, go and ventilate them at Scopa. The answers that the committee has received here has been through my nudging here in this meeting. Because I think
No.
that sentence,
Okay.
I take a strong exception to it, actually.
Okay, so thank you, Honorable Deputy Minister. Look, I don't want us to now do a back and forth on that dispute. Suffice to say, your point is taken, Honorable Deputy Minister. I was dealing with you on precisely ensuring that there is accountability here today, and I understand, I know the efforts you went into to make sure that that happens. I think my understanding of what Honorable Madlala was saying was that questions that basically the board should be able to provide the answers. They are quite capable. They shouldn't rely on you on whether they should answer, because they were dealing with the issues themselves. I don't think he was saying do not speak at all. But as I've said, I called you to say what is going on, and you intervened and we're here. So can we please leave it at this? Because otherwise we're going to do this back and forth and never deal with the questions substantively. The ref had not finished answering the members' questions. Do you have a follow-up?
Yes, Chair. Because, Chair, I had asked specifically this, because you can't give conditions that would generally result in a precautionary suspension and say you place someone on a special leave. I think we must all agree that it means then the board has a problem as well. Because after he has refused to come here or he was not taking their directive, they should have placed him on precautionary suspension. Then they must tell us, what is the problem? Is the board the problem? Or what is happening there? We need to not play around with this thing, because there are two things. You can't give conditions for something else and then you do something else. Thank you, Chair.
Thank you. I think Honorable Maduna's point is well made and understood. Can we then deal with the questions arising as well as the original questions? Because I'm worrying that we're going further and further, and there were some questions asked. So let's deal with all of them, please. And then I will go to the last three members of the committee to ask questions.
Yeah, Chair, thanks. Maybe there's just one issue that I need to indicate, because I think it arose around the ex-court members would have been instructed not to come. I think I just need to put it on record that after the communication from the announcement from the board chair, EXCO had a meeting yesterday, chaired by the CEO, where it was agreed that we're coming to Cape Town. So that I just want to put that on record, that we you will know that when these invitations are made, as executives, the invite is not to us specifically, but to the CEO. Obviously, the CEO.
Sorry, Honorable Shengwa, please switch off your mic. I'm going to give you an opportunity, please.
I think it's important, because there was a statement that there was an instruction that we must not be allowed to come here. And I just want to make sure that, for the record, that there was an EXCO meeting which decided that we'll come here. And of course, there may have been communication between the CEO and the chairperson of the board that we may not have been privy to in the process. But I think it's only honest of us to indicate that we, at no point did we specifically get any instruction from Mr. Litswalo that you shall not go to Cape Town. Hang
on. I've got some questions to ask you, Mr. Lukwarin.
Yeah.
No, members, please.
Yeah.
When did you know you must come to Cape Town?
Yes, like I said, you would have received.
No. When did you know?
Yesterday.
Thank you.
Yes.
What time yesterday?
Yeah. Our meeting started at? Yeah. 12. Yeah, 1:30, yeah, around 1.
Okay, I do not dispute what you are saying. So as of yesterday, even though the Road Accident Fund and yourselves were required here, you still did not know that you must come to Cape Town.
Yes, because I think there was, yes, that's correct.
That's all I'm asking. So, when did the letter was sent to the Minister and Road Accident Fund when? Last week.
You're saying the response to the chair.
The invitation, no, she will tell me. The invitation to the Road Accident Fund was sent on the 12th of May. In the intervening period, it's your submission that you were never informed at all that you must come here.
No, no, I'm saying that there was a position of the board. I think you also have indicated.
No, please, Mr. Lukwarin. I'm asking you a different question.
Okay.
I am going somewhere with this. You and I are going to end up at the same place. You need to walk the steps with me. I know what I'm doing. Since the 12th of May, the ministry and the chief executive and the board, on or about the 12th of May, let us say the 13th or 14th to allow for the passage of time. But that would be some 10 days minimum from today. None of you, can I ask, when did you start preparing the presentation for today? Who prepared the presentation? I want to know, who prepared the presentation? You did.
Yeah, Chair, like I said, in terms of the context, you recall that some of the issues that were raised from your letter.
No. I just want to know who prepared the presentation.
That is provide the context, Chairperson, because the information was readily available. I prepared a presentation over the weekend, and as a secretary.
Please don't read into my mind why I'm asking the question. Who prepared the presentation?
The board secretariat prepared the presentation based on historical information provided, and I shared with the management for confirmation, Chairperson. So in other words...
Please assist me.
Yes.
I know why I'm asking the questions in this way. Please answer, listen carefully, don't be nervous. Answer the question I'm asking you only. You prepared the presentation.
The first phase of presentation, it was me, Chairperson. Then the final input, it was the secretary.
I need to I am going somewhere with this. I'm going back to Mr. Lukwarin, by the way. I am going back to Mr. Lukwarin in my own way. You prepared the presentation. Who gave you the instruction to prepare the presentation?
Chair, after I've interacted with the chairperson of the board, I took the initiative of preparing the presentation. Thank you very much.
When was that interaction?
The interaction was last week Friday, following your response to the response of the letter of the board expressing the view that they're not going to appear in the board to the committee on the basis of the SIU investigation, Chairperson.
No, Mr. Lukwarin, you go into details that I did not ask, but thank you for that. So not Mr. Lukwarin. Secretary, you go into details I didn't ask. So the situation we have is that on the 12th of May, we transmit a letter of invitation to the ministry and the chief executive and the board. And as of last Friday morning, you still did not have an instruction to prepare a presentation for today. And the committee usually gives a date by which the presentations must be submitted. This was my anxiety. This was my anxiety that I was getting lawyers' letters in that time. So what we know is that as of Friday morning, there was no preparation to come here because we're being bombarded with lawyers' letters. When did you complete the presentation then?
Yeah, Chair, it was completed on Friday because recall that there's an internal process, quality assurance process from the board secretariat to management to the board and ultimately to the minister, because the minister has to quality assure the checklist before ultimately submitting the presentation to Scopa, Chair. But like I said, the context was in relation to the, okay, thank you, Chair.
Did Mr. Litsualo make any inputs on the presentation? And if so, when? So when you say it was sent to management,
Chair, can I ask with respect, because usually we communicate via the office of the CEO. I don't know, the acting chief corporate support officer would maybe touch base with that, because as a point of conduct.
Is
we
that
share
person?
with
Is that person here?
Yes, Chairperson.
Can you please tell us, did the CEO interact with that presentation at that point?
Yes, Chair, the CEO did interact with the presentation.
Okay, so Mr. Lukwaren, when did the chief executive tell you for the first time you must come here?
Chair, I think it is I'm saying that we had an EXCO meeting yesterday that resolved that we're coming here.
So, you see, so please switch off your mic.
And my can I just explain my understanding of the presentation that was that Ms. Manyasha is referring to, that it was at least at that point the understanding that the board was coming to the meeting because remember there were letters. There was a meeting even from the perspective of the board. There was an understanding that on the basis that the initial invite was specifically based on the matters of the SIU, there was not going to be attendance. And that was even the position of the board.
Mr. Lukwarene, I asked you a simple question. Please answer it. When were you told for the first time that you've got to come here?
Yesterday.
Thank you.
I think I've
that's all I asked you. That's all I asked you. When were your flights booked?
Yesterday.
Do you understand the anxiety of the board? Because your answer, say, is disingenuous. And I would advise you not to do that. All weekend, I was working because your colleague was refusing to come here. So, Mr. Lukwaren, he had no intention of informing you to be here until the last possible moment. I am telling you, I'm not asking you. It's clear, it's expressed in his letters to us. He had no intention. He only did so because he had no choice in the end.
Yeah, thanks. I think all I'm saying is I was trying to deal with the fact that we were explicitly instructed that we should not come here. And I think I just wanted to address that. I hear your point
you were not explicitly instructed, but you were kept in the dark. That's your version. Substantively the same thing. Please continue with answering the questions.
Yeah, no, it's fine, Chair. Thanks. I think in terms of the questions, I'll start with the questions, I think, from Honorable Maduna. I think Honorable Maduna asks about the duplicate payments and the steps taken to prevent the duplicate payments. I think we have responded to this issue, Chair, earlier on. As I've indicated, indeed, we have implemented measures that resulted in the recovery of the duplicate payments, which were subsequently submitted to the SIU for recoveries. And following from this, there have not been further duplicate payments identified even through the auditing process from the AG, and I think it's a focus area that they focus on as part of their audit, and I think that for us is the testament of the effectiveness of the measures that have been put in place to deal with issues of duplicate payments. And I think, as I have indicated, the recoveries process is an ongoing process that the SIU is seized with. On the issue of the fraudulent payments, the specific transaction, Honorable Maduna will have to beg your indulgence to come back to you on the specific issues around the progress on the DC process in relation to the specific matter. Honorable Kosana asks about the panel and the issues around the criteria to allocate briefs. And I think as I touched briefly on this during the presentation itself, the one of the key criteria obviously is looking at the complexity of the matters and the experience of the specific firm, but particularly when they are already seized with a matter that is similar to the issue, or maybe they have handled with a similar matter before, and like I've indicated, there are also instances where a matter would have been allocated to an attorney, and as it progresses up in the stages of litigation, that particular attorney continues to handle that matter for purposes of continuity. And why the increase in cost? The increase in cost obviously is a function of the volume of litigation that the RAF has to deal with, and in most instances, you will find that it is the decisions that the RAF has taken that have been challenged, and obviously the RAF will have to challenge same. And I think that's the main. And I think you'll see that most of the cost, obviously, it's mainly on the disbursements to councils, senior councils, as it were. So I think that's the main reason. I think we have seen sheer volume of litigation, and some of the matters have been complex. If you look at the discovery matters, the SARS matters, some of those matters have been very complex matters, and they've gone on for a lengthy period. Whistleblowers, how effective is the mechanism to protect whistleblowers? Like we've indicated, the furthest you can go really as an organization is to ensure that the process of reporting is independent. And in this regard, we have an independent service provider, Vuvuzela, who handles and manages all the reports around fraud, and we are very open in terms of conducting awareness to staff on reporting fraudulent matters, be it within the organization or across with other law enforcement agencies. As you would know, that even the SIU proclamation in question, we went to the SIU to also ask them to assist with some of the investigations, particularly the complex matters around the duplicate payments. Most of the preliminary investigation would have also been done by the groundwork would have also been done by our own forensic investigation unit. So I think that's the rationale and the process around that. And I think as I reported, we have a forensic investigation division. We also have an ethics management division, which specifically focuses on issues of conflict of interest and things like that, and in terms of ensuring that we are compliant with the governance processes. So I think that is I think the other questions were more specific to the CEO's appointment and the board issues, and I think the ministers and the board chairs has covered those. Thanks, Chair.
All right, so can I say, and this is my request to you, Board Chair, because the point that Honorable Madlala and Honorable Maduna raising is a very valid one. The conditions under which the Chief Executive is not here are cloudy from a legal perspective, and also in terms of what we ordinarily expect from the process of labor law. And I would like that this be rectified immediately. and by immediately, I don't mean next week, at the earliest time that you can confirm, because the points the members are raising are really valid. You can't ask a person to go and reflect. What are you asking them to do? You either are holding a person accountable or not. Refusing to turn up to Parliament to account is an extremely serious matter. It's an extremely serious matter. If we allowed it for one day to happen, that would be the end. And your response cannot be an uncertain decision, a decision of the board of uncertain quality and meaning. That's a concern of the members, in that we still don't know legally what's going on. And that's why I asked about the conditions. So as part of your submissions, I would ask that this is treated as a matter of urgency. As part of your submission to the committee or report, you clarify that matter so that when I distribute that to the members, it provides a certainty that the members require, because it's clear that this decision was taken without legal consultation, as you said. You need to consult urgently, and you need to do the right thing in the right way, in line with what labor legislation and your fiduciary responsibilities require. Thank you. So we're going towards the end. Honorable Kubeka, Honorable Atkinson, and Honorable Beck. I nearly said Beasley.
Thank you, Chair, and greetings to the House, greetings to the Minister, greetings to the Board, greetings to the Executive and Parliamentary or the Scopa staff and everyone joining us. Chair, I think we are somewhat, or we hold somewhat of different views with certain things that are happening here. Or Chair's out. I think with, when I say we hold somewhat different views, I think when the SIU presented to Scopa, it was ventilated, and must be noted that this was outside of RAF. RAF was not around. That the presentation was based largely on allegations. The whole presentation by SIU. That the presentation, that is the reason why we're sitting here. It had issues like, it appears that so-and-so did this, it appears so-and-so did that, it appears this is what happened. And again, it also had, it is alleged that so-and-so did this, it is alleged that so-and-so did that. Now, when you then say, and you take those allegations and you bring them to a committee like Scopa, and you say, no, this is the entirety of the investigation, I'm bringing it forward to Scopa to say, these are the findings. We argued in this House that it may not necessarily be correct to have the SIU presenting on allegations that are not tested. I think I ended up saying, just to close off that meeting, I had an issue with, because I had an issue with the allegations, I even said the problem that's going to happen or that we're precipitating by accepting such allegations is that the people who are supposed to be the subject of those investigations, they're not here to answer for themselves, to say, okay, this is true, this is not true, and explain what is the issue and what happened. But I also actually ventilated the fact that the media will take whatever presentation that the SIU brings to this House and they will run with it. And I was told that no, even if the media runs with it, people still have a right of reply. They will have a right of reply. Now, what is happening here is, and the problem is, we have to note that bulk of everything that we're saying here and all of the questions that are being asked are asked about someone who's not here. And for me, that's a huge, huge problem because it's unfortunate that the CEO is not here to answer for himself. He has other people answering on his behalf when the people who are answering don't have the full spectrum of information that he would have as a CEO. And still, when we sit here and everything that is said here will be taken out to the media and the media will run with it, even with that same incorrect information. I think I want to ask a couple of questions, Chair. The first question is, when the board sat and was deliberating on the suspension of the CEO, the suspension and or precautionary suspension, was that a full board sitting? Who was there? Who was not there? That's the first question. And the second question is the decision to put the CEO on special leave the decision of the whole board? And I think this has, we have dabbled somewhat into that question on what was the basis to put the CEO on special leave. I think with Honorable Madlala asking the way he did, I'm asking basically the same question, but I just need more clarity on that one. Because the CEO's absence here and the way that he was suspended, to us seems like, or to me at least, seems like a way to silence the CEO. What is he being silenced from? What is it that he was going to bring here? What is it that he was going to say here that was going to implicate perhaps some people, or that was going to get some people in trouble? Because you can't tell me that on the eve that he's supposed to come here, he's not here. I think the acting CEO said he didn't know that he was going to be presenting today until this morning. So we must highlight that. I think the acting CEO said that he flew into Cape Town with the CEO for them to come and present to SCOPA. That to me, again, says this was a deliberate, the suspension was a deliberate attempt to silence him before he comes to this committee to respond to the SIU preliminary findings. And it somewhat is, it looks like that was done deliberately to ensure that we speculate on his guilt in a sense of competence. The question then stands, what information is being blocked from being shared with SCOPA by making sure that it's not here? Is the decision, the next question, oh yes, I did ask this, that if the decision to put the CEO on special leave, was it the decision of the board or not? The next question, was the CEO interfering with the investigations by the SIU? And if he was, I'd like to know how, because maybe the reason why he was put on leave was he was interfering with the investigation. If that's the case, I would like to know why. And I say this because the investigation is mostly into matters that were before his time. And I want to know, who else has been placed on special leave? Because the board took a decision to suspend the CEO for whatever reasons. Now, the SIU investigation, some of it at least, falls before his time. So is he the only person that was put on special leave? That's another question. And interestingly enough, a couple of weeks ago, I saw on social media, there was an interview that the CEO did, I'm not sure what platform that was on, where he exposed a lot of damning information about judicial corruption. Now, was that perhaps not a trigger for the board taking the reckless, well, I'll say reckless because the board chair just confirmed that they did not take a legal opinion on how to suspend him. And I think, just lastly, Chair, this is a comment I made when the SIU when we had that meeting with the SIU. I said, we must appreciate that the committee sittings are public knowledge, and we must also appreciate that they are aired to South Africans. And we must also appreciate that the media will run with whatever this committee says. And that those media reports will say this will say that this is not a conclusive report, because again, goes back to the SIU report. It was a preliminary report. It had a lot of, it appears, it is alleged, yet we sit here today. Thank you, Chair.
Thank you very much. Honorable Atkinson.
Thank you very much, Chair. I must say to the board members that I thought your response to the CEO was very restrained, considering the implications he has basically landed you in. And I say this because Advocate Matibi was here talking to us about the SABC about 2 months ago. And the SABC board agreed to a number of issues that Claudia Motsoeneng wanted, special bonuses for himself. He made decisions, policy decisions, as far as the SABC was concerned, which had quite major cost implications. And at the end of the day, they tried to get as much of their money back from Mr. Motsoeneng as possible. But when he couldn't pay, they went after the board. And they also basically went after the board where it could be proved that losses had occurred and the board had been party to that as well. So what I'm saying is I do believe that the CEO has actually placed you all in a very, very difficult position, because I think when it comes to the investigations around things like doing away with the panel of attorneys, which has potentially cost RAF billions of rand, okay, when you did get reports not to do so, or not to have, at least not to get rid of your attorneys without something in place to protect the state from loss. Potentially, if that's taken back to the board, potentially people could come after you to make up for that loss. So that's why I'm just saying, my request to you is to try and return RAF to legality as quickly as possible, which I'm following what the Minister says about stopping court cases, and also about considering things like the illegal board notice about additional requirements that are put in place before you'll pay claims. Because the other thing that's a huge concern about what your CEO has done is the fact that he's made additional requirements for claims to be paid out, which are not in law. They're actually not in the RAF Act. So the RAF Act gives you exactly what is required to pay a claim out. And I know what's happened is that people have sent claims in, and they've been sent back to people. Now, he thinks that's okay. But unfortunately, there's a legal liability on the state for that. And that could potentially be massive amount of money. So through his illegal actions, through the illegal board notice, at the moment there's an unquantifiable liability of the state, basically, for his actions. So in protection of yourselves, I would suggest as quickly as possible, you return RAF back to a line of accountability in line with the law and in line with the RAF Act, and that you desist from any further legal action, okay? Because it could all actually come back in your lap, and you could be ended up expecting to pay. You and former boards as well, who might have allowed the situation to exist. Now, the second issue is this one of vetting, which I find very, very concerning, because the reality is if it can be shown that the RAF CEO was not properly vetted, and if we're saying over 7 years in the organization, he'd not received a security clearance, it's quite possible that everything that he's been doing is actually outside of the bounds of law. I also received information that he didn't receive a security vetting when he was at PRASA. So I don't think the man has ever received a proper positive security vetting. And if he did as he did, where he came before this committee and represented himself to be vetted and was not, he could then be held in legal terms to be mala fides. Okay, so you had bad intentions. And basically what that does is it puts at risk any decision that he made, and it also puts you in a situation where he in his position could be contracting on behalf of RAF or have the legal persona to do so, but actually because he was not correctly in his position, because he wasn't correctly vetted, and because he actually wouldn't go through the polygraph test. That's why he hasn't actually got his security vetting. Okay. And never had any intention to. So he could stay on that list forever as pending. But that was never going to happen because he was never going to take the polygraph test. It can be shown that all the money he spent on taking the Auditor General to court is actually unauthorized, fruitless and wasteful expenditure. So for that reason, I would ask her to desist immediately from any further legal action. And I'd also ask the Minister to check in law and maybe just to check with the State Security Agency, if I am correct, whether Mr. Letsalo ever received a security clearance. And also in the people on that list as well, whether any of those people listed are deemed to be cases closed, in which case they haven't received a positive security clearance, and they can remain forever pending. But if the case is closed and you're told the case is closed without a positive security clearance, then in essence you're operating outside the law because you're no longer in a position where you can be employed. Okay, so I do think it's one of the very, very critical issues that we're facing with today, and we can't operate forever with slides that kind of leave a whole lot of questions in the air. We actually need these things to be resolved, and we need to know whether Mr. Letsalo ever had a security clearance, and whether there was ever any likelihood of him doing so. And I would ask that if he does apply for the job after August, that one of the requirements made is that he can come up with a security vetting, because I would find it unconscionable that he could apply for that job again after operating for 7 years without a security clearance. The other point I wanted to make was with regards to the letter that was received by this committee in connection with the CIO. So just to state in just very general terms, basically what the lawyer's letter from Viewer Incorporated told us was that they acted on behalf of the CIO throughout the process, in other words, through his issues that he had with the city of Johannesburg. So in other words, they knew everything had happened, so they can't claim to have no knowledge or be unsure of the information.
So Honourable Atkinson said they were acting for who?
They acted, Voyo Incorporated, who's the lawyer's letter that we received. They were operating on behalf of the the acting chief investment officer. Okay, all right, okay. And in that letter, it states that the city of Johannesburg decided to withdraw all charges of misconduct, that there was a mutual separation agreement, all of which is stated and well documented and backed up by concrete evidence, that their client, Mr. Madiba, did not leave the city of Johannesburg with any charges over his head. Their client feels aggrieved because the chair mentioned him in a manner that has already been finalized, and information opined by Scopa is inaccurate. Scopa urged to refrain from using false information. Members of Scopa warned not to entertain wrong information concerning their client's departure from Johannesburg. Okay. So the reality in that is that we sought information from the city of Johannesburg, and I would just like to state the facts of what we received there. So as regards the first point, sorry, I'm just trying to open this properly. The charges against Mr. Madiba, so this is question one. The charges against Mr. Madiba were dropped because the city of Joburg no longer believed that he had a case to answer, okay? And the answer from the city of Johannesburg was that, according to our records, the charges against Mr. Madiba were not dropped. He resigned during the disciplinary process at C Annexure A. Question two, from Scopa. There was a mutual separation as part of the settlement. Mr. Madiba resigned and the charges were reciprocally dropped. No, there was no mutual separation between Mr. Madiba and the city of Joburg. There was a proposal for mutual separation from his representative, which proposal was rejected by the city of Joburg representatives. Subsequently, the employer resigned and left of his own volition. Question three to the city of Johannesburg. Mr. Madiba resigned of his own accord before the disciplinary inquiry could proceed, and since he was no longer an employee, there was no longer reason to pursue the matter any further. Mr. Madiba, the answer from Johannesburg, Mr. Madiba resigned during the disciplinary process when parties could not reach any consensus on mutual separation. Okay. So the issue we have here, which again is extremely serious, is we've been lied to again. So Mr. Madiba instructed a lawyer to send us a letter with falsehoods and lies. Okay. Now, I think the situation here is that certainly the board needs to speak to Mr. Madiba and see whether you want to continue to employ him on the basis of a lawyer's letter sent to Scopa, which actually does not cover or does not attest to the information we received from the city of Johannesburg. And I'd also ask that the committee chair reports the attorney to the legal professional counsel, because the lawyer himself cannot say that he didn't have any knowledge of it, because he states in the letter that he is aware of the situation from the beginning. So he knew the exact situation that took place in the city of Johannesburg. Yet we've been sent a letter that does not reflect what happened. In essence, a lie has been sent to this committee under a lawyer's letter, under the full knowledge of Mr. Madiba and his attorney. So we would ask that that attorney be reported to the Legal Professional Council and that that letter be subject of investigation. Okay. And then a final question around the issue of the call center contract, okay? We'd like to know some questions with regards to the contract for the call center for some 300 million that has gone through at the Road Accident Fund. How and where was this tender published? Who received the tender? What was the value of the contract? And who are the directors and stakeholders in the company? Now, we do believe that that tender was worth 300 million. And what we would like to know is obviously an answer to those questions, but we would maybe like an indication from the CEO, acting CEO, or members of the board, whether all due process has been followed with that. And also the question as to why you went for the same person for a 400 million rand data cleanup project, which is underway, and whether that has actually followed procedures, and whether if those two tenders are investigated by the SIU, they will turn up to be completely above board and all clear. So we would like just to get a little bit of an indication that the board and the executives here are happy that all correct procedures have been followed with both those tenders, 300 million, 400 million, who went to the same person. Thank you very much.
Thank you, Honourable Atkinson. Honourable Beck.
The Deputy Minister has spoken quite empathetically that it is his position, and it's also on the public record that it's the Minister's position, that the board should drop the Auditor General court case, which is now going to the Supreme Court. So I want to know whether the board is able to provide the minutes of a board decision taken to drop that case, and if not, what the heck is going on? To the acting CEO, what is your position on this case? Do you think it should proceed? I want to briefly pause there, Mr. Chair, because this whole accounting standard thing sounds quite boring, but it's actually creative accounting that's going on here. The Auditor General has told us quite clearly that if we use the globally recognized accounting practices, then the liabilities of the RAF will exceed 320 billion rand as opposed to their recorded 36 billion rand. So they're putting on their books 10% of their means. Not only is the RAF insolvent, its liabilities likely exceed its assets 3 times over. And I wonder if we understand that fact that I've now tried to explain, whether all these other things start to make a bit more sense. Delaying claims for as long as possible, going about who gets appointed on what terms in the most ridiculous manner imaginable, tolerating a rogue CEO by a totally inept board. All of those things make sense when you take into account that this entity is probably so deep underwater, chaos is the only solution. The second question from the board chair, and if not from her, I just need a technical answer before I can actually ask the actual. The second line item there says Mopoyana. Is that Mopoyana Ledwaba Attorneys? Is that the correct law firm? Just for the record, that's a yes, acting CEO.
Yeah.
So there's a firm extracting 30 million rand a year from the RAF. It's got 1 director, 3 senior associates, an associate, a secretary, and an admin clerk. Does that seem right? Does that seem reasonable, Madam Chairman, that a firm with that staff cohort could be extracting that value and delivering value? And then finally, my last question is to the Deputy Minister, who's not only an honourable member of the House, but in my estimation, from everything I know, also an honourable man. And he himself, when he was chairperson of this committee, had indicated about a year ago that the RAF should start declaring their directors delinquent. And so my question now is being asked in a constructive, not in an accusatory manner, because of the estimation I hold of you. Would you agree with me that it's not correct to say that this unvetted board is making decisions, including decisions to impose additional conditions when people apply to the Road Accident Fund, which just 2 months ago has been found by the High Court not to be imposable conditions? So when they're making decisions like this, when they're maintaining the CEO as they are, when the accounting standards is leading to this likely insolvent situation, and if you then consider, Mr. Deputy Minister, the RAF Act, Section 10.3, which reads as follows: the Minister may remove a member of the board referred to in subsection 1B from office if there's sufficient reason to do so. So given your past estimation of what this board is up to, given what we've seen here today, given these things I've just mentioned to you, would you not agree with me that it's perhaps now time to say that this constitutes sufficient reason to start with the chair and one by one remove the board members that's leading to this situation?
Thank you very much. Can I hand over to you to start with Honorable Kubega's questions?
I would thank you very much. I think, Chair, let us be fair to the issues that have been presented here. Nobody is silencing the CEO. I think it's a very dramatic characterization of facts. By his estimation, he was not coming to the meeting here in herself. He was not coming here. When the scoper, see, we didn't wake up and say, yeah, we're coming here. We received a letter of invitation calling us to a meeting. I told my office that whatever has been placed on the diary for today must be cleared so that I could come to the committee because we have been called. The board met, Chair, and took a decision to explain issues and then say it would not be coming here. Wrote to you. The CEO wrote to you saying he's not coming here. Who's silencing who? You are given an opportunity, come and explain here, when you say you're not coming. Then, on the 20th, this is a letter, Chair, you received on the 22nd of May. On the 23rd, I wrote to the chairperson of the board and the board, amongst others, and I would like to read this letter now so that I can clear all this whatever. I say, the above matter, which is the invitation to brief scope and the SIU investigation. The above matter in your letter, to which I have been copied, to the chairperson of the Standing Committee on Public Accounts, dated 22 May 2025, refers. 1. The matters you raise in your letter are duly noted. 2. REF is hereby directed to honor the Scopa invitation to appear before the committee on Wednesday, 28 May 2025, and in that meeting, ventilate the matters you raise in your letter to the chairperson. 3. Furthermore, please be informed that I intend to meet with the board of REF on Monday, 9 June 2025. Further details in this regard to follow. Then I say, parliamentary oversight and accountability are non-negotiable, especially when so much is wrong in our country, and thus are an absolute necessity for the long-term sustainability and viability of our constitutional and democratic dispensation. Therefore, those who hold offices through election, appointment, or deployment must accept, without exception, they will be held accountable for how they exercise their duties and for the performance of their respective entities. Lastly, the REF is further expected to ensure due compliance with the committee deadline to submit a presentation by 1600 hours on Friday, 23 May 2025. I'm not sure how clearer you can get to unsilence. Then, Chairperson, a presentation is sent, and at 4 o'clock in the office, my staff is called to say we are recalling that presentation, Which then brings me to this. The quality assurance, therefore, would not have happened because the presentation was pulled, right? Then, Chair, the chairperson of the board advised me that in light of all the things we have narrated here, a board meeting was taking place yesterday morning. She phoned me in the morning to advise me of that, on all of this. And a decision was taken in the morning. The executives met at 1 o'clock after that decision had been taken. What I will not, Chair, sit here and accept is a characterization as if there is something on the part of the ministry, the board will speak for itself, to prevent people from coming here. I directed the board to come here. I directed the executives should be here. When I spoke to the chairperson, she then responded and said, in fact, DM, the committee has responded to the issues we have raised. And in light of that response, we have agreed that we will appear before the committee. This is in parallel to all the issues, Chair, and the work that you were doing. The minister was abroad on a working visit with the Deputy President, with the acting DG. We were liaising on all these matters in the midst of that with one outlook, that the board and the executives must come here. Yesterday, up to yesterday, there was no bookings for the executives to come here. None. I asked acting DG, I said, I know you would have just returned from a working trip and we have got a lot of things in the department, but I think it's prudent that he's here. And he said, no, I'll definitely be in the meeting. We have brought the public entity oversight entity unit of the department here. Why? Because precisely we are against silencing. Now, the board takes a decision to place the CEO on special leave, who has indicated, amongst others, that he's not coming here when that decision is taken. Then when the decision is taken, a meeting of the executives is convened. In fact, I take strong exception, Chair, to that line of response that was given here, and I intend on probing it further when we meet. So, when we ask the question, when the statement is made, respectfully, Honorable Gupek, I think let us be fair to the material set of facts. We have made every effort possible to prevail on everybody to come here to prevent a situation of people being silenced. I said, all these issues you are raising in your letter, I note them. Go and ventilate, go and, in fact, I even said, go and empower the committee with your perspective so that they know where you stand on all these issues insofar as the SIU. Can I be frank with you, Chair? Ordinarily, I could have wrote to you and told you I'm not coming here because the SIU has not briefed me. But that's not constructive because the committee has got views. The SIU has presented a preliminary report. For me, oversight is an enabler to help us arrive at the correct decision. I reject the notion in its totality that anybody is being silenced. In fact, we wanted everybody to speak. Lastly, Chairperson. We are saddled with a situation of a decision that was taken by the board to place the CEO on special leave. Whether a legal opinion was sought or not, that is secondary. An opinion is an opinion. It's just like economists. They all have a view on why the rand is up or down. You will present the same set of circumstances and two different lawyers will argue them differently. In its composition, the board amongst others, has got a legal person. It is incumbent on the board to explain, as it has committed to do, and I have assured that will happen, to provide a detailed explanation to the committee about this decision. The legal person, the advocate on the board, is on the board precisely to provide legal opinions. It doesn't mean now we must go out and find one. The committee will be provided with an opportunity to react and respond to what the board will produce. And it is my commitment again, Chair, to say the timeline that you have provided will be met. And lastly, Chair, I have indicated here, on the 9th of June, a board meeting has been called, and the issue around the CEO will be placed on the agenda of that meeting. And then the question you asked, Doctor, about the board, we will make a determination about the entire ecosystem of the Road Accident Fund. My only regret is that this issue of the CEO has overshadowed the issues that we wanted to raise here when we had insisted, Chairperson, that they must attend. I'll ask the question, when was the flight booked? Nobody in this room here can dispute the fact that they were not coming. As at Friday, Chairperson, I was the only one who was coming here. Nobody's being silenced. Because these things, Chair, they feed into the public discourse just like we are asking about other things. Let's not sneak into the public narrative wrong things. Every effort was made to prevail on the board and the executives and the CEO specifically to be here. Other things, because I don't think they are material. But in the final analysis, the board is here, I am here. A decision after the board's decision was taken by the executives when they met at 1 o'clock when the board had met in the morning. I think, Chair, let's follow the sequence of events correctly.
Sure. Yeah. Thanks very much, Honourable Minister. I was going to ask you to conclude. Thank you. So the question is, did the board take the decision in order to silence the CEO? It's a simple question, to paraphrase.
Absolutely not, Chair. The decision was to avert a CEO who refused to come and attend SCOPA and also influence the executives not to. I mean, the sequence of events will actually confirm that. Thank you.
All right. Thank you very much. I'll come to you, Honourable Gubbe. Can we deal with the questions? Because I don't want to lose track. I also need to manage time, and I also need to ask my own questions.
Yeah, Chair, just to respond to the first question, you currently be aware that there are 11 board members. So in terms of the required quorum, it's 7. So for the record, the meeting was legally constituted because we have 7 out of 11 board members. Thank you, Chair.
All right, thank you.
Chair, are you done?
So that there's no ambiguity. On the board, there are 2 vacancies. One is of a financial person where we are in the process of filling that vacancy. The second vacancy is the representative of the department following resignations, and we are filling that vacancy within the dictates of the due process. It is a responsibility which resides with the ministry and the department, and work is underway to ensure that those vacancies are filled, so that there's no other thing.
All right, thank you.
Chair,
Sorry, there were lots of questions asked, so we need to have them dealt with.
of the chair, is she?
Sorry?
Seems we're skipping over to the acting CEO, but the chair isn't answering her questions.
Okay.
Chair, I think, thank you members for the questions. The questions really were relating to the discussions around the conditions of the CEOs and whether the removal of the the CEO basically, and there were sufficient reasons for that, and I think we will respond to that in writing. And also there was a question around whether the board was fully constituted, and I think that question was answered. But the other matter was around the Concord matter, which we will go into it and review as a board and come back. Yeah, I think most of the issues were around the circumstances surrounding the CEO currently, which will be responded to in detail by end of next week. Thank you, Chair.
I will come to the follow-ups.
Okay, thanks, Chair. I think the only issue that I think was specifically referred to from my end would be from Honorable Atkinson. I think the specifically around the contact center. I think which contract, which we would obviously be able to get the details around that. But I think to the best of our understanding, this is a contract that ordinarily would also be audited by the Auditor General as part of an internal audit. And I think this is one of those that would also have gone through our internal audit assessment. And I think I just did not get the other part of the second contract that you said is similar to this, that I think, so that we're able to go check for you.
It's a contract for data cleanup and data management,
Okay.
and it's apparently with the same company. Yeah.
So I think it's something that we'll check. But obviously, at a broad level, all our contracts are audited, and I think as we did with the outcome of the with the Auditor General from the previous financial year, procurement was the focus area. And I think you'll recall that from a procurement perspective, we were given a green, and I think that's why we will also respond on the issues around irregular expenditure. But certainly, to the extent that there are those issues that you're raising, then we'll look at that. I think that's as far as I can take it. I think there was also the issue of I think that they raised around the AGSA. I think the chair has clarified that they are going to review the. I think you
Minister gave the instruction on the 8th of May. We're now at the 28th. What have you done?
Yeah, I think it's a board decision that.
Why has it not been taken?
Sorry, Honorable Beck.
I think let's.
Can you complete your answer?
No, I was saying that with regard to the AGSA decision, the board chair has clarified that.
It's not clarified.
But can I complete?
So
to be lie.
So sorry, the Honorable Beck. So complete your answer, because I did not hear the chair's answer to this. But complete your answer, because that's why I'm making provision for follow-up. So Honorable Beck, just hang on.
Yeah, what I thought I heard the chair said was that the board is going to review the decision as advised. I think she can confirm that. But I think from the specific question that you had asked around the nature of the dispute from a management perspective, I think that's the one that I wanted to maybe give the CFO to clarify what are the issues. But I think around.
I asked if you agree with it. That's what I asked you.
Honorable Beck, can I clarify this? So the question, Mr. Lukwaren, actually, because Honorable Beck is also forgetting his own question. The question was, now that you are the chief executive, what is your position on the litigation? That actually is just a question. Leave the chair out of it. You were asked a direct question. Just answer it. If you have a position, say what it is. If you don't.
Yes, Chair, I think the position is in relation to the current accounting policy. As remember, we implement the current accounting policy, and that's the position that we hold. at the moment. I think nothing has changed.
The one
in
that the court
relation-
told you is wrong, the one the minister told you is wrong. Is that the position you hold?
I'm saying that's the current accounting policy.
How's that working out?
Honorable Beck, I'd like to be the interlocutor here. Can you please, because I'm worried about time and this is wasting time. Your accounting policy, therefore, says you must continue to ignore the Auditor General and the accounting standard, even though the High Court, you've lost at the High Court, the Supreme Court of Appeal has refused to hear it, the Judge President has refused to hear it. Your position now, because there's a simple answer, is that you will continue to therefore follow the current policy, which is unlawful.
Chair, I think it's unfair. Chair, sorry, Chair.
No,
Chair,
Honorable Kupeka, can I finish the question? You asked your questions. What I'm asking, Mr. Lekwareni, is really simple. The question is, what is his view on the litigation? I am trying to help him to get to a straight answer. And that straight answer is, if your view is that you are going to follow the current policy which has been rejected by the courts, is that your position? That's what I'm asking you. I'm not making an allegation, it's a fact, and I was placing the proof points on the table. The High Court disagreed with you. The Supreme Court of Appeal disagreed with you twice. One, they refused to hear the matter. Two, you appealed to the Judge President. He dismissed the matter and refused to hear it. That's the situation. I'm simplifying your answer. Is your answer that your intention is to follow your current accounting policy, which has been rejected by the courts? Yes or no?
Chair. No, I think, Chair, I think you have been unfair. All I'm saying.
Honorable Beck,
no,
please. Can you please just?
No.
I've asked a question now. Can you please? Please answer the question.
All I'm saying is there is an accounting policy that is approved by the board, and that is the accounting policy that then is used to develop and prepare financial statements. And to the extent that accounting policy still persists, then that's what is going to happen. But like it was indicated, the board has got the prerogative to review the accounting policy if there are changes, and there are processes that we've been embarking on. We've been in communication with the department around the process around that. We have even written to be in engagement with the ASB on the process, because there are challenges. There are real challenges. And that is why I wanted the CFO to explain.
Mr. Lukwaren, can I just say, you are now getting yourself into trouble unnecessarily. You've answered the question. You have answered the question. Don't be nervous.
No.
Because the substance of what you are saying is that you can only follow the policy, this policy that you have, that has been rejected by the courts. It's simple. There is no... Don't go further. We've ventilated the issues in the committee before. I don't need the CFO, who actually never speaks when we are here, to relitigate the same issues. You've given an answer. It suffices. I'm not going to go back to Honorable Beck. You've given an answer. It suffices. We know what your answer is. What is the CFO going to tell us now? You've answered. You've said you've got a policy. It hasn't changed. You will follow it. That policy has been rejected by the courts 3 times is something the board will have to do something about. But you will follow that policy. Is that correct?
Yes, I'm saying correct. That we'll follow the policy until it is reviewed.
Thank you. That was all. That was all.
Chair, I'm sorry. I like things to be clear on the record, because I know how this committee works. When the acting CEO says they are in discussion with the department, for the record, there's no discussion to be had. The position from the minister and myself is clear. The road accident fund is to revert to the accounting standard which the AG has pointed them to, until such time that the ASB has made a determination of which they know is a process currently underway to find that standard. That's number one. Secondly, for the benefit of members, after that very clear instruction, the Road Accident Fund is in the Concord on this matter after they had failed at the Supreme Court of Appeal twice. I can ask you to put it to them.
No,
Who signed-
I am. So the less we litigate this issue,
but
because I have questions on that.
For the purposes of your clarity, Chair, I think the Chair, when she must come back, must take you into confidence about that decision. Ask them who signed the papers to Concord.
So sorry. Okay. So Honourable Deputy Minister, I am going to deal with the issue substantively. By the time we leave this room, we will have ground it to a fine print. Believe you me. We are going to get to the bottom of how the decisions are made by this board around matters like that. That is why. The question you've answered, Mr. Lukwaren, it's simple. Don't explain further. You've given an answer, it suffices, as far as I'm concerned. Okay? And Honorable Beck, we will come to the questions that the Chair must answer. Honorable Gubeka, also as a follow-up, I'm going to get to that. What I don't want is to get lost in the questions and then we don't complete. I need to be certain that the initial questions asked have been answered. And then we're going to come to follow-up. And the follow-ups must be concise, please. No long statements. I have a lot of questions to ask, and I won't leave here without asking those questions. So if you were noting the questions, right? So as far as you're concerned, you've dealt with all the questions.
Yes, I can be reminded if this there.
A 6-person law firm.
Yes, I think the question around the firm, I think I had explained the rationale, the criteria used to do the allocation.
Does it seem reasonable to you as the question?
That
30 million rand to 6 staff members.
You really need to give witnesses the opportunity to answer questions. Otherwise, it's going to delay us, please. Nobody's going to dance around me. Can you please? Otherwise, this meeting descends into chaos.
We can also do what Honorable Burke is doing. We are keeping quiet out of respect for you because we've also got follow-up questions that we would like to ask. But if Honorable Burke keeps on interjecting while people are talking, then we won't get anywhere.
Yeah, I agree with you. So, Honorable Beck, please. I had said I am going to give opportunity for follow-up if there are outstanding issues. And I need to be sure, Mr. Lukwaren, that you've dealt with all the questions and that all we're left with is follow-up. And that's the opportunity, Honorable Beck, to say you have not answered question 1, 2 for me. So, please, please proceed.
Yeah, I think as I previously explained, that mainly the cost driver is the complexity of cases allocated to a specific firm. And for example, in the case of the firm in question, they would have been the firm that would have handled even the SARS matters, even some of the complex matters. So if for example a firm has such an allocation and the matter is prolonged for a number of years, goes all the way to the Supreme Court of Appeal, for instance, obviously the cost will be significant. And I think some of those are disbursements to cancel fees, for example, as I've previously indicated. So that's the firm in question is in the panel, and therefore was allocated those responsibility to execute. And I think that's the issue. So it's about the complexity of the matters that they are handling.
Sorry, Honorable Black. So, Mr. Lukwaren, can I give you advice on answering more concisely? Because you don't help yourself. And let's please take a deep breath here. The question is, do you believe that the law firm that appears to have scant capacity internally is qualified to get the amount of work that is worth that kind of money? That's the question. Okay, and I don't want to keep playing people's answers back to them. And I'm now going to ask you a question which gets us to a more concise answer. Are you saying that law firm, it is your view that that law firm is competent? Secondly, is the only law firm or one of a few that can handle the complexity of cases that you say that law firm handles with senior counsel? Is that your contention?
Yes, Chair. Like I've indicated, the cost is determined by the complexity of matters that they have handled, and the repeat briefings are determined by the successes they've registered in the previous cases. And I think that's not necessarily about the. I will not comment about the size of their firm, because I've not been privy to that. But all I'm saying is that the basis for the volume, or rather the quantum of the amount that you see, particularly when I look at just the two matters that are in front of me in terms of that they have handled, that's what drives the cost. And I think that if to the extent that they're in the panel and they are competent to be in the panel, I don't see any unreasonability in that.
So Mr. Lukwareni, can I ask, I'm going to now walk you through the answer here. Who briefs these attorneys on specific matters?
The head of legal.
Where is the head of legal?
Yeah.
I am here.
Please switch on the microphone. Is it on?
Yes.
Can you tell us about these two law firms?
Which two law firms, Chair?
The ones that have got 83% of their business, the top two law firms. There's Malachi and there's another one. Between them, they've got 84 million out of 107 million rand business. What cases are they handling?
Chair, I would not know all the cases on the top of my head, but I know with Malachi, they've been handling the discovery. They're handling the AGSA matter. Mponyana Lidwaba, I suppose that's who you are referring to as the second one. They handle the Mabunda and others and other persistent cases that are happening from the former panel of panel of attorneys. They're handling the SARS matter, and they are handling the Malawi matter, which I think Malawi, we've got like 10 cases of Malawi matters that are happening. But I must stress to the committee chair that most of the amounts reflected there are amounts that are then paid to councils. So those are council fees.
We will get there. Could you please, for the two law firms, provide the committee with a detailed breakdown of the fees? Provide us with the cases, provide us with the attorney fees, provide us with party costs, provide us with the cost of counsel. Am I leaving anything out? Punitive costs, all of that kind of thing. Can you provide those? The reason I want this is that you have persistently been clobbered on the AG matter. By a law firm you continue to pay. And you see absolutely no reason to seek another law firm. Please provide those details, and we want those details by close of business tomorrow. Please send them to the Secretariat. Thank you. Okay, are there any outstanding questions? Honorable Gupega, your hand was up. Was there a question that was not answered for you? Honorable Trolip, I'll come to you.
Chair, it was more a comment than a question after the minister had elaborated on the question that I had asked. It was largely based on the same, as much as I understand that minister is elaborating on the sequence of events and how things happened. But I don't want us to lose the fact, Chair, that the SIU investigation was largely based on hearsay. So now, the Deputy Minister is elaborating that the CEO and his team were still contemplating on whether they are coming to Scopa or not. Now, that's according to the information that we've received here. If that is the case, and we are summoning the executive to come and speak here to us and answer us on largely what is hearsay, and if you'll recall, Chair, that SIU report kept on speaking about issues like it is alleged that so-and-so did this, it is alleged this is what happened, it is alleged this is what happened. It appears. Now, if that is the case, Chair, we must then be sensitive to understanding what the issue was with the executive coming to speak to us on what they deem as allegations.
So, Honorable Bega, I need to address this myself because I made the decision
Please,
about what's going to be traversed here. First of all, on a general principle, the SIU updates us on ongoing investigations, generally speaking, like yesterday, ongoing. There are two types of guardrails that are put. In fact, there is a general guardrail that is put on information. If a matter has already been ventilated in the public domain, in other words, there's an attempt to recover assets and that kind of thing, or disciplinary action has been taken against employees, etc., those are named. Where the steps are yet to take place, we are simply told these matters are at this stage, and we are not told who those employees are. And I would like to beg you to have regard for previous presentations of the SIU. That's the general standard. That's the first thing. The second thing is that I made the inquiries myself. So I had 2 meetings with the SIU, and I know you raised the issue. I have since taken legal advice, and I'm comfortable that we're doing the right thing. Here is why. I had a discussion with the SIU prior to this meeting to make sure that to that previous meeting that the guardrail is put in place. The second thing is I kept asking questions deliberately to ensure that notwithstanding the use of the word allegedly, it is made clear why it is being used. You can go and consult the record. I asked a question, for instance. Are you certain that the money that is said to flow to employees does indeed flow to them? And they said yes. I said, explain how you arrive at that conclusion. They explained. I then said, is it your submission to this committee that the only thing that is remaining is that the said employees must explain why the money is in their bank account? And they said yes. I said, otherwise you know for certain that that money flowed to their bank accounts, and they said yes. The only thing that is outstanding is that they must tell us how the money has ended in their bank account. You can, honestly, I swear, go and consult the record. Therefore, it is incorrect, Honorable Kubeka, to say the SIU investigation is based on hearsay. It's just not factually so. Because I asked these questions of the SIU, and the SIU answered them in the manner that I have just outlined. Hearsay is so-and-so told me something was happening. No. The SIU explained in detail. We can't go back to the recording now, but if you want to, you can. The reason I walked them through is because I was not satisfied that they're providing the comfort that this is not hearsay. That is why I asked those questions on that day. So that we are left in no doubt that this is not hearsay. The only reason they're saying that is it is believed. There were 2 words. It is believed and allegedly, if you recall. I then zoomed in on that deliberately, and I asked them about method. And Advocate Motibi went to detail about method. So, Honorable Kubeka, as much as I would like, the last thing I want to say is that in this meeting so far, we have not asked who these employees are. Nobody has accused the chief executive, for instance, as a person who's not here, of anything other than refusing to come here, which is in your folder in the form of a letter from him. There is nothing else. I don't know if he's implicated or not. None of the members know. You don't know. That's not because I can't ask the SIU. I can. It would be inappropriate to discuss that level of detail in this meeting, and we are not going to. I have no apprehension that so far we have prejudiced the chief executive. The only thing he's not here to answer, because the only accusation is that he has said he's not coming. And I have a letter to that effect, and I've shared it with the members. It's not an accusation. He wrote me a letter via his lawyers to say he's not coming. That's the only thing we have discussed here about him. I do not recall anything else. There hasn't been anything else, Honorable Member. I would now like to ask the questions, please, because I haven't had an opportunity to ask the questions. And we're going to run out of time, and the questions are really pertinent to the proceedings. Honorable Skosan.
Yeah, Chair, I did not want to come in. I'm also mindful of time. Yeah, but I think the issue of hearsays, I think it needs to be addressed. I think because I think Comrade Kupega, he keeps on repeating it, and I think it's quite unfortunate that he makes such a characterization in reference to the SIU. I think, like we have correctly indicated, they would say it is allegedly, it is believed, because they are still investigating. But to say that is a hearsay, I mean, a hearsay is a rumor. When you hear something outside, then you come here and present it. So if we characterize that as a hearsay, we mean that the SIU, they just hear things from outside, either from the media or from TikTok, then they come and present to the committee. So it's a very wrong characterization to say the SIU is basing their things on hearsays. No, it's not hearsays, but they would use allegedly, or it is believed, because they are still investigating. So when they are done, when they present a final investigation, they would obviously remove those words. But we can't say that's hearsay, because a hearsay is a rumor, something that can't be substantiated, Chair. Thank you very much.
Members, so please, can I beg your indulgence? I really need to ask very pertinent questions. Not that they're better than yours, but this inquiry will be incomplete. Can I please do that? Okay. Oh, so, okay, sure.
Just a point of clarity, I'm sorry I arrived late. I was at another portfolio Chief Whips Forum. I just want to ask the Ministry and the Board a simple question. Did the Ministry or the Board endorse or sanction the CEO's defiance? If not, what steps were taken to address the defiance? And if the decision to grant special leave is based on an endorsement of his defiance? That's all I want to know.
Okay, so Honorable Trolip, so we traversed exactly this ground already, so I will summarize. Okay, so firstly, neither the board nor the minister endorsed the decision of the CEO not to come here. It is for that reason, among others, that a decision was taken by the board to place him on special leave. We have had a back and forth about the appropriateness of that measure in light of the issues. Then we took some time to dig through some of the issues, but short answer is neither the board nor the ministry endorse the minister not being here. I think you walked in as we were at the tail end, so thank you. All right. I need to ask some questions of the board. One of the matters we've raised before here has been the issue of the panel of attorneys. I asked, in fact, it's been the issue of default judgments. I asked the team, the RAF team last time, whether they were confident, and I'd raised two matters. The first one was the sheer volume of road accident fund cases in the Gauteng High Court system, where Judge Sutherland has said they're responsible for 56% of the backlog, such that if you enroll a matter today, it will be heard in 2029, 2030. The second matter was and related to the default judgments. And the chief executive said it's under control. I have regard for a judgment of the High Court last week on the 20th, which an excerpt of which I've shared with the committee, but I will in summary say the following. There was a default judgment given for 6 million. The Road Accident Fund asked for it to be rescinded. They sent an attorney from the state attorney's office. She told the judge that she would actually not be arguing the matter. She was merely sent to observe. Firstly. The second thing is that the judge took serious umbrage at averments made under oath in the papers, all of which were just plainly untrue. For instance, they said the previous hearing was held virtually, it was not held virtually, it was in person, and on and on and on. In the result, the Road Accident Fund is on the hook for over 6 million rand plus interest, 1. 2, the judge says on the week of the 20th of May, I think the week of the 5th of May, he gave default judgments to the tune of 25 million that week. He is also aware that other judges in the same court, and we're talking about one division, were similarly situated to the tune of 50 million. Does that sound like an environment where these default claims are under control to you? And it's a direct question.
No, Chair, definitely not. We will look into those recent decisions, because when we inquire about these matters, we are given a different view in terms of there's a proper risk assessment. And also we were given the impression that the state attorney model is the most cost effective, and these people are briefed appropriately and they have the experience to deal with the matter. So we were not given the sense that these are not even able to present the RAF appropriately, especially, I mean, what you raised before, I said they're just coming there to observe. So, Chair, I do say that it's not acceptable. We will take the matters into consideration and look into them.
Let me ask the head of legal. What is your approach to these matters? Do you know how many default judgments you've had this year that are undefended, like this one?
Chair, I would not know at the top of my head, but I do know that there is a default judgment court roll at the High Court on a weekly basis, and there's quite a lot of those. We've been having meetings with the judiciary at the High Court in terms of how to handle them. Part of it is that we are provided with that court roll, and beforehand we see with operations what matters are settlable, so that then they don't go the route of going to the court. But we are aware of that.
Are you aware of the judgment I'm referring to?
No, Chair, I'm not, because every week there's a number of them. I'm not aware. It has not been brought to my attention, yes. Because RAF is highly litigious, Chair, so I'm not going to claim I know each and every case that goes to court every day. So that's how the situation is.
Okay, so it is your, and I'm going to move on from this as much as I want to, but it is clear to me that there is a raft of cases. This is why this is relevant. It's relevant for 2 reasons. The chief executive of the Road Accident Fund has come and bragged here about how you've cut legal costs. What has happened is you've cut legal costs on the legal fees side, but you're racking up expenses on the default judgments in matters that are undefended, to the extent that the Special Investigating Unit has identified more than 4 billion in default judgments. And this is why this is important. South Africans are unhappy about the fuel levy in this moment. And the fuel levy leaks through default judgments where you send underprepared, inexperienced state attorneys to court, where you're asking for the matter to be rescinded. But you then proceed not to argue the point. Who's the advocate on the board?
She's not here, Chair.
Okay. It is unheard of for me that you ask a court to overturn a matter and then you don't turn up to argue it. It's unbelievable. And yet I get the sense that the judge is exasperated. Are you aware of the letter written by Judge Sutherland complaining bitterly about the road accident fund cases to the legal profession and to the Johannesburg division of the High Court about a year or two ago? No, Deputy Minister, I'm speaking to the head of legal. That's a job.
Not to my recollection, Chair. When was it?
Are you aware of anything?
Honorable Beck, please. So I will find the letter. This was on or about year before last. It's an old letter. The matters have been persisting. So it's clear to me that the default judgment issue is not receiving proper attention either from you, the executive, or the board. And the state is racking up bills on matters that are unattended. Because that 4 billion that the SIU is investigating is a drop in the ocean, clearly.
Chair, can I request there's statistics that looks at the number of default judgments that we have and how we have done throughout the years that we can share with the committee?
Please do.
Bring the stats.
But for me, in 1 week, 50 million in 1 week is a staggering amount of money. Because in 6 weeks, that is 300 million. That's the one issue. So I want that information. Let me turn my attention to the issue of vetting.
Apologies. I think it would be unfair to the committee if I do not indicate that on this matter, as I tried to explain earlier on, we have rolled out a process with the Department of Justice and the Solicitor General and the High Court Division in Gauteng on the court management processes around ref matters, precisely because of the issues you are raising. We have set up a team, and I'd assume that maybe legal would speak to this, with Deputy Minister Nell and myself and all the stakeholders. There are quite a number of issues that the courts themselves have raised. We are trying to borrow working models in Mpumalanga and in Limpopo, amongst others, to deal with the court management. We're looking at issues around mediation with the courts, because the other issue, Chair, which is emerging, it's less about the merits of the case, but about the financial commitments that are attached to it. So I would request, Chair, that Etenobos, I think today may not be sufficient. We can provide you with how far we are parallel to all else that they are doing. But there was a recognition on the part of the ministry that an intervention was required. And the next step now is then, of course, to engage with the judiciary. And the last point on this, Chair, I still maintain that it would be to the benefit of the committee to engage with the LPC.
They are coming next week. And
the Health Professions Council. We are saddled with ref matters that they have raised about law firms that are not resolved. So what I will do, Chief, they are coming next week. I can ask ref to furnish you with their information and their perspective. I do believe we need to resolve the challenges which are within the ref ecosystem and the courts, because there's a matter that Honorable Gupega raises around judicial corruption. And I think it's a very bold statement, which we must sort of tone down on. Yes, there are lawyers whom are appointed as acting judges and then have ref matters in their roles in the law firms. We are going to be engaging with that. So I wanted to say from the ministry side, in as much as that's work being done, we are trying to now plug in an intervention, because Gauteng is the most populated around these matters. Thanks.
Sure. Thank you. let me turn my attention to the vetting issue. And the chief executive and myself had a back and forth, in fact with you, Chair, about the fact that acting people are not even submitted for vetting. You recall that conversation between us. And I asked you about risk. I then asked the chief executive about the status of the chief investment officer in light of what is in the public domain via court papers that we then had access to. The matter has since been ventilated by Honorable Atkinson. It took me one email to obtain the information from the city of Joburg. Don't you think it should have been possible for the Road Accident Fund to do so?
Thank you, Chair, for raising that point. Chair, that matter, the board took it seriously. The subcommittee of the board, REMCO, is actually reviewing that matter. So they're almost halfway through with that review. I don't want to call it investigation because normally boards, they don't get it to investigation. They have to appoint somebody else, but they are working with the internal processes to review that. So they'll be bringing the matter to the board ASAP when it's complete. But we are taking it seriously. It's under our radar and it's being reviewed. We'll bring it back, the results.
I raised that matter in October last year. That's how long ago it was. I raised that matter in October last year, Chair. The length of time that has elapsed with yet no information, and in the intervening period, all I have done is to ask Denzel to draft a letter, and I dictate and we discussed it over the phone. The executive mayor of Johannesburg, Councillor Dada Morero, gave the answer that Honorable Atkinson favored the committee with that information. I am not certain what you need to be doing, but what we have is a contradiction between what the city of Johannesburg is saying and the letter of attorneys, and I'll come to that right now because it's also very material in another context, the attorneys who sent us the letter to Parliament. I do not accept, Chair, that it takes you this long to establish something that took an email that Denzel and I did in 4 minutes. The committee has on numerous occasions complained about state employees who leave just before disciplinary action is taken and they get employed elsewhere. We have such a situation here and it's unresolved. I do not expect a single member of this committee to say that is okay, because they were complaining about it yesterday. They even asked for a registry. It's taken you since October to do so. It's unacceptable. Are Road Accident Fund employees allowed to use law firms that are on the panel of the Road Accident Fund for their personal reasons? In terms of your policy, is it allowed?
Management should respond in terms of the policies, but it shouldn't be.
Thank you.
Conflicts of interest. But acting COO, please.
Yeah, no, it wouldn't be allowed to.
Members, you have a letter in your folder from the lawyers of the Chief Investment Officer. It's on the panel of attorneys of the Road Accident Fund. It's VOI Incorporated, unless there are two. So let me ask, what steps then need to be taken when that occurs? Because my concern is that that firm is now doing that work on the dole of the Road Accident Fund. It's on the panel.
Yeah, Chair, I think when there are allegations, or particularly around conflict of interest, an investigation will have to be conducted if that is the case, to establish the merits around those issues and in terms of how it arose. So I think that is how it will be handled if there are those issues.
Well, there are those issues. What I'm saying is not speculation. The members have it. You can show the spreadsheet again. They will see it. VOI Incorporated is the law firm that's acting on behalf of Mr. Modiba. So we have a situation here where the same employee, and I'm coming back to oversight and governance at the Road Accident Fund, where a person leaves a state entity just before disciplinary action is supposed to be taken. They are employed at the road accident fund. It is the submission of the chair here that because that person is acting, has always been acting, they were never going to be vetted until I intervened. They are still unvetted. They send a version of their departure at the City of Johannesburg to the committee that is contradicted by the City of Johannesburg, and that employee proceeds to use the same law firm that is on the panel of the road accident fund. The level of oversight the board has over the road accident fund is exceptionally deficient. It's exceptionally deficient. May I ask about the case with the Auditor General? Have you received senior counsel's advice on that matter? And if so, how many counsels did you get opinion of?
Chair, we did get senior counsel on that, which were taken out of the panel. It's probably from the same, if I need to be corrected. But we've received, I think, about 2 senior counsel on the matter from the time the matter started.
So let me ask this. Was that advice to did the board seek its own advice, or did you go with management's senior counsel's advice?
Chair, whenever we need legal advice, we normally have to go through the legal process so that we don't bypass the process. So we allow management to go through the process and appoint on our behalf. So the short answer would be through management, because we don't go through procurement processes. And we do that, we instruct the board secretary, and then he ensures that the due processes are followed.
So are you aware whether there was any, so in other words, do you know in total how many counsel were sought for advice? Here's where I'm getting to, because I've seen it happen. Management shops around for senior counsels or counsel's advice that is going to agree with their position. So that's a concern. That's why I'm going with this. So do you know for certain if what was passed on to you as the board was the only advice sought by management?
Chair, possibly, because their view was that they needed the senior counsel who's actually au fait and understands the complexities of the case. But I take your point then that in fact I raised that matter in the last discussion, that we need to get somebody different to give us a different view on the matter. And I've also raised the fact that the losses in courts actually point out to the deficiencies of the lawyers that are representing us in this matter. So that is on record. And that's why I'm saying we need to go back and review this matter. But we will rely on the senior counsels appointed by them, and they will explain and say, it's actually better to bring somebody who has the history, because they actually understand the complexities of the matters, because RAF is not a simple and straightforward organization, and then their accounting issues are even more complex. So that has been the rationale behind it.
Thank you. Let me ask the head of legal. Were you responsible for securing the counsel's advice? Was it just counsel, or was it a silk that provided the advice to the road accident fund?
Chair, it's Silk.
Okay, so following the decisions of the High Court, did you have further consultations with counsel?
Do you mean in terms of saying what's the next step? Yes, Chair.
Correct.
Through our law firm, of course.
How did counsel advise you?
That we still have a case, Chair.
Then the matter went to the Supreme Court of Appeal, and the Supreme Court of Appeal, as I understand, the matter was never argued, was it, in the Supreme Court of Appeal?
They just said consideration, correct?
What was the decision of the judge president?
Our application was dismissed.
How long have you been a lawyer?
I'm not a lawyer, Chair.
Oh.
Yes.
What's your field of practice?
I'm the Chief Governance Officer. I've got an MBA and I've got various governance certificates.
Chair, have you been aware that your head of legal does not have a legal qualification?
Chair, can I make it clear? I'm not the head of legal. I'm the Chief Governance Officer. And in my structure, there will be somebody who's the head of legal, currently still vacant.
Order, Chair.
Do you have a head of legal at all? Do you have somebody who's responsible for the legal function at the Road Accident Fund?
I've got 3 senior legal officers, yes, Chair.
Okay, so who makes the decisions? Because clearly you are like me. You are not competent to make the determinations in advice. So who advises then management in the EXCO on legal matters?
My senior legal officers, Chair, who have LLBs, yes.
Please do me a favor. Can you please send us their qualifications to the committee?
Senior legal officers.
Please do. Okay. Send those to the committee, because what is clear? All of them. Because what is clear is that the Road Accident Fund does not believe any of them are competent enough to be the head of legal. And you've operated all of this time without the person who should be overseeing that work. And the board has been okay with it. How long has the role been vacant?
I was just trying to find out. Justice left just when I came to RAF, so it's like 2.5 years.
So here is, and I'll come to you, Honorable Member. So here's the situation such as we have now. You have embarked on expensive litigation. And I was going somewhere with my question around this, because when a court refuses to hear a matter, they're basically saying you apply for leave to appeal, you may get it in the same division, the matter gets dismissed. As I understand, your matter served twice in the High Court. Then you went to the Supreme Court of Appeal. You tried to get it in twice. It was rejected. A competent legal officer would know that there are no reasonable prospects of success. This entire frolic has taken place with no head of legal at the Road Accident Fund, with 3 junior legal officials being the people that the EXCO and the board are relying on, and that has been deemed to be okay. It's wild. Do you understand why there is a problem?
Chair, firstly, it's senior legal officers, they're not junior. The second point is that's why we've got a corporate panel of attorneys to then seek counsel and advice from them on such matters. In this matter of the AGSA, we've got one of our corporate panel, who's Malachi Incorporated, who are assisting us in this matter. And we've got Jabu Motebe, who's a senior counsel, and Kululi Steps, who's a junior counsel, who are assisting us in this matter. And we then seek the advice accordingly.
Your statement does not answer my question. It's completely unhelpful to you. You have a vacancy that you are, by implication, telling me that you don't need to fill it. Why haven't any of those people been appointed to the role, if they're sufficiently competent to fill that role?
Chair, we have tried, I for one have tried to fill that vacancy. We failed twice to get a suitable candidate. One where we thought we are winning, they failed the preliminary test that they needed to do in terms of their ethics and behavior. So we could not appoint. So that's why we did not. But I'm not talking about my 3 seniors. I'm saying trying to fill in the head. And my seniors are still new in their positions. Therefore, they said they still need to find their feet within the RAF to be able to then see if they'll be fit for the positions. So I can't force them then to act.
Ma'am, so I am going to leave this inquiry here and I'm going to make a conclusion at this point. The Road Accident Fund, whose work is heavily reliant on the court system, and the amount of money that leaves the door is reliant on the court system, does not have a head of legal. And your chief executive goes all over the country holding press conferences, complaining about lawyers when he does not have in his exco the person who should advise the Road Accident Fund accordingly. That's the picture that we have. It's like breaking something and then complaining that it doesn't work. 2.5 years is a long time. The Road Accident Fund also does not have a chief claims officer. The two most critical functions for the Road Accident Fund, claims and the legal function. Chair, is there a chief claims officer at the Road Accident Fund, permanent?
Not yet, Chair. I'm actually, yeah.
Okay, no, so there isn't.
No.
How long has that role been vacant?
Over 2 years, Chair, to be,
Okay, so Minister, or Honorable Deputy Minister, this board is failing. This board is failing. I haven't even gone through half of my notes here, and I won't. This board is failing. It is, here's the implication, Chair. Submitted to this parliament is a budget by the Minister of Finance, which is contradicted by only one institution, and it's the Road Accident Fund, in respect of its liabilities. Because the Road Accident Fund, on the guidance of no head of legal, has decided to litigate and proceed to do its own thing. I was going to ask you, ma'am, in your knowledge, but you've just told me you're not a lawyer. In law, if you appeal a decision, you comply until the court sets it aside. The Road Accident Fund does it differently. It does its own thing anyway, even though it has failed repeatedly in court. And we have a strange situation in this parliament where the budget submitted by the finance minister and voted on by the National Assembly in October last year is contradicted by the financial statements of the Road Accident Fund, which sadly the Transport Portfolio Committee has approved. It turns this country into a banana republic. And the minister is correct. And Deputy Minister, the board is failing. Vacancies in critical positions, litigation without a head of legal, people in position who are still trying to find their feet, lawyers who rock up in court to try and overturn a matter, and they don't argue it. Inability to send a simple email to a previous employer to ask about the appropriateness of an employee, who then proceeds to send a lawyer's letter, which is suspect at best. Deputy Minister, please, this situation cannot continue any longer. It's making a mockery of this parliament and oversight. In your submissions next week, please tell this committee what it is precisely you are doing to remedy the situation. We can't simultaneously have South Africans toying against the fuel levy. And this is the train wreck that we are listening to here. And people get paid to sit on the board.
Fully agree with your statements, Chair. I'm deeply concerned that we've spent 4.5 hours in this committee meeting. We gave the acting CEO the benefit of the doubt when the day started. You repeatedly asked him, who's the head of legal? Can I ask the head of legal? And only when you asked a direct question of whether that person has a legal qualification, did they turn around and say, no, they're head of governance, which is misleading by deliberate omission, this committee, which is disrespecting it. And so I would then say that the acting CEO seems to be behaving no better than the previous CEO.
Chair, it's really just to follow up to my comments earlier. When I made an appeal to the board to follow the correct legal guidelines that had to do with the panel of attorneys, with looking at properly defending cases, and also obviously following the correct accounting guidelines as well. I'm just wondering what the board is going to do about defending these cases. So we really do need to see action taken to save all this money that we basically losing. And as Chair said, people are toying against the fuel levy. You know, we want to make sure that that's not all been spent in default judgments. Thanks.
Thank you. So please, can we please get that information asked for by the members, including the board taking a proper decision around the chief executive, because that's an important procedural matter. And can we please get the submissions in writing? Thank you very much for your attendance, Honorable Deputy Minister, Board Chair, Acting Chief Executive, honorable members, colleagues from the Auditor General and the SIU, and Acting DG, and your colleagues and other colleagues from the Road Accident Fund. Thank you very much. Yeah.
Can we just get clarity on your timelines? There's a matter that you've asked the head of governance to submit tomorrow, then there's issues for next week.
That one must come tomorrow.
We just get clarity as to what gets submitted when, even if it's through the Secretariat by end of today.
No, the only thing that we need by tomorrow is what we asked the head of legal or the head of governance.
Okay, everything else is all right. Thank you very much, Chairperson.
Thanks.